This court is not sitting tomorrow. If it is really urgent, you can move the bench roster. So this court is not sitting tomorrow. If it is urgent, we will take it. Otherwise, take your chance on Monday or Tuesday. If it is really urgent and you want to move the matter, then tomorrow. Monday. $2:30. Tomorrow. Monday. Is it really necessary? Then Monday, Tuesday. Monday, Tuesday, ಯಾವಾಗಾರ ಹಾಕ್ಕೊಡು. Tomorrow. Monday. ಯಾವ್ದು ಮಂಡೇ ತಗೊಳ್ಳಿ, ಇಲ್ಲಂದ್ರೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ ತಗೊಳ್ಳಲ್ಲ. How can we now hear this matter at the fag end of the vacation? ಬಾಕಿ ಎಲ್ಲ ಅರ್ಜೆಂಟ್ ಮ್ಯಾಟರ್ಸ್ ಇದೆಯಲ್ವಾ? ಯಾವಾಗಿಂದು ಅದು ರೆಡ್ ಪಿಟಿಷನ್? ನಾಟ್ ಅಟ್ ದಿಸ್ ಸ್ಟೇಜ್ ಅಲ್ಲ. ಈಗೇನ್ ಮಾಡ್ತಾರೆ ಇವ್ರ? What is the urgency? You can move the next page, right? Urgency idra move ಮಾಡಿ. We will take urgent Monday.
Sorry.
Taken as further parted. If you've got a case, it will be there before the next post also, right? So take your chance. We have lots of further hearing matters. We need to dispose. Okay. 2016 is the appeal. Then at that time you did not say anything. You have filed an application. You have filed any application to stop the construction then? See, when there is no application, any direction, how can this court give? Final hearing ಈಗ ನಾವು 2 ದಿವಸದಲ್ಲಿ final hearing ಮಾಡ್ಬಿಡೋಣ. So take your chance after this. Fresh matter tomorrow. Monday. If it is listed, if it is listed as further hearing, then we will take. If it is not, then no. But then what happened? It is heard as part heard. No, there is any order of hearing the petition in part heard. No. Then first. All the matters are settled. Oh. Okay. Yes. First October. First, ella first. The pre-conciliation is also on first. Right, all the matter. ಆ matters first ಗೆ ಬರುತ್ತಲ್ಲ. Joint memo. Party is present, petitioner. Both of them have signed. We'll dispose of the petition in terms of joint memo, right? We need not pass a separate order to the guy. For both the councils, joint memo is filed. Duly signed by the councils, stating that the parties have agreed to settle the case, settle the matter, and the writ petition needs to be modified in terms of the joint memo. The terms of the joint memo reads as under 1 and 3, 1 to 3. In terms of the joint memo, the writ petition stands disposed of. And accordingly, the award is modified. The corporation to pay the terminal benefits within a period of 8 weeks from the date of receipt of this order. At request of the appellant counsel, this matter after Dasra vacation.
Minutes. Serial number 20 minutes, if I may submit.
Serial number?
20 minutes, 20. Please,
Just a
minutes,
moment.
please.
There's a mention they made physically here. Who are you? Have you informed the appellant? Will you inform or have you informed? Martivi. At request of the responding counsel, this matter after the vacation 2022. Yes, Mr. Counsel, which serial number were you mentioning?
My lords, serial number 20 minutes. I am for the appellant. There is a inconvenience to me, my lords. I am out of station for my son's admission. May kindly we had this matter after vacations, ma'am.
Yes. Who is this acknowledgement for having served the purpose on the
Minutes, government minutes. We have served a copy. I'll file that as well.
you have been served? SCGP acknowledges the receipt of the appeal papers. Hence, the office of the note of the office would not survive. This matter at request of the appellant counsel after the vacation 2020.
For hearing on IA minutes, there is a IA minutes in this.
Yes, it is on the very state which it is listed.
Much obliged.
Yes. Yes. Who has to take notice? H.B. Devraji is directed to accept notice for the respondents. Petitioner counsel to serve the petition papers on the learned counsel. This matter after the Tuesday. Fresh in the fresh matter. Yes. Your recommendation comes your way.
In 78, for which restriction number 69 was given an alternative. 75. In 75. Last 3 sentences of the letter. Last 3 sentences. legal license ಸಾಧಾರಣವಾಗಿ ಮಾಡಲಾಗಿದೆ. So, behind alternate allotment. Legal license legal basis. Not a permanent allotment even. But the petitioner what was allotted is but also on a legal license.
Have you stated so in your objections? No, what have you stated in your objection? What they say about that person who has been allotted a separate and another alternate site for in light of the shop being burnt, that is shop number 69. That is that para number 4. So you will also be given on leave on license basis. In similar terms to correct. In similar terms to the shop number 69, which has been given. So we will dispose of with that direct. What is that? Correct. That would be a continue, right? On, but only on basis of leave and license, not as a permanent allotment. Is it not?
Yes, because the 69 will be done.
Where is that? 59, no? What is the documents you have produced?
Not show that it was allotted.
Krishna. Is seeking for a writ of mandamus or direction to the respondent to allot the shop to the petition. The facts are that the petitioner asserts that he was allotted a temporary shed number 50 in APMC market located at Yeshwanthpur for a period of 11 months based on the terms and conditions set forth by the respondent. And subsequently, the license of the petitioner was renewed by paying renewal fee and professional tax to the Assistant Commissioner Tax Officer. It was the case of the petitioner that the respondent number 2 had issued a license for the year 1987-88 with a new shed number 70 in APMC market for 11 months. The shop bearing shed number 70 met with an accident in the year 2000 and he had given a representation to the respondent for seeking for an investigation and for reconstruction of the shed to continue his trade. It is a case of the petitioner that they have given documents to indicate that they are in that he is in possession, that he is in possession of the shop number 70. Further, the petitioner made representation requesting for allotment of shed and commission agent license. And no orders have been passed by the respondent on the said representation. Where is that endorsement? Where is that recommendation? What is that page? What is it? Annexure. It is case of the petitioner that the petitioner made an application under the RTI seeking information as to the measure taken by the respondent to address the grievance of the petitioner. And the reply received was that the respondent number 2 committee in their meeting dated 24/2/2021 has deliberated on the grievance of the petitioner and had decided to allot the shop to the respondent, which finds place at annexure R3. Annexure R3 of the petition papers. And also, the petitioner has produced the legal notice, legal opinion with regard to the shop held by the petitioner. Legal opinion of the advocate, which is at exhibit annexure R5. It is the contention of the petitioner that despite the resolution bar recommendation made by the committee to allow alternative shop to the petitioner, the respondent has failed to allot the shop, and the representation which is submitted by the petitioner along with the requisite documents indicating that the petitioner is entitled for the alternative shop as recommended in the resolution. The respondents on one or the other pretext is calling upon the petitioner to produce certain documents which are not relevant, and in light of the documents produced by the petitioner and in light of the resolution of the committee of respondent number 2 to allot the alternative shop to the petitioner. The respondent number 1 filed statement of objections, and supporting the statement of objections, learned counsel for the petitioner and learned counsel for the respondent submits that the respondent to their notices had called upon the petitioner to submit 1 allotment letter allotting the temporary shed, 2 license copy, 3 agreement entered with the market committee, and 4 market fee paid details. And that the petitioner, having not produced any documents sought by the respondent, The respondent has issued an endorsement to the effect that the document sought by the stating that since the petitioner has not submitted the documents sought by the respondent, his request could not be considered. Then a counsel submits that the respondent had passed a resolution on 24/2/2021, considering the fact that the shop number 70 of the petitioner was burnt down, along with the shop number 69, and the allottee of shop number 69, that is Mrs. BKS Enterprises, have already been allotted alternate shop number 19/31 in Coconut Block. And hence the respondent has passed the resolution recommending for allotment of shop number 28/31 in account block to the petitioner on leave and license basis, which would be subject to the approval of the Director of Agriculture Marketing, Bangalore. And that the respondent has sent the proposal to the Director for approval of the allotment of shop, and the Director, by letter, had asked the respondent to produce the allotment letter given to the petitioner for shop number 70. And the request of the petitioner would be considered only if the petitioner if the petitioner could produce the allotment letter pertaining to shop number 70. In support of his contention, learned counsel submits certain documents by way of memo, which are the documents sought by the respondent calling upon the petitioner to produce the allotment letter. And unless an allotment letter is produced, the recommendation as deliberated by the respondent would not be considered. Could not be considered. The petitioner was issued a license for shop number 70 for the year 1987-88, which is seen from the petition papers, and which is not annexure F, and which is not disputed by the respondent. What is contended by the respondent is that it is a license for 1 year, and it is not an allotment, and the petitioner has not produced any document to show that the petitioner was allotted shop number 70 in order to get the benefit of an alternative shop. It is also not in dispute that the shop number 70 caught fire the year 2000, prompting the petitioner to seek accommodation due to the loss of the original premises. The petitioner was directed to produce the allotment letter to support their claim for alternative accommodation, which according to the respondent is necessary to substantiate their claim, the petitioner's claim for alternative accommodation following the fire accident. It is a case of the petitioner that they are unable to produce the allotment letter for alternative accommodation, as the shop had caught on fire and the allotment letter is not available with the petition. Although it is contended that there exists a recommendation by resolution for such an allotment by the respondent number 2 committee. The recommendation letter, the recommendation bar resolution dated 24/2/2021 indicates that there was an acknowledgement of the need of alternative accommodation. The absence of formal allotment letter does not negate the existence of the recommendation, which may support the petitioner's claim for alternative accommodation. Which support the potential gap in the regulatory framework regarding the issuance of formal allotment letters versus the recommendations, the recommendation plays a pivotal role in the pursuit of alternative accommodation to be provided to the petition. As stated by the respondent, the other shop which had caught on fire, shop number 69, was provided with leave and license, and on similar terms, the petitioner also needs to be provided with the accommodation of alternative shop. In these such circumstances, this court passed the following order. Writ petition is allowed. The respondent is directed to allot alternative shop in terms of the resolution passed. Resolution dated 24/2/2021 by allotting alternative site in terms of the allotment provided to shop number 69. From when did they give the representation? When did they give the representation? When did they give the representation? Correct. You should have passed some orders, right? Immediately. What is the market rate? What is the rate given to the shop number 69 now? Correct. If you had considered that representation of theirs at that point of time, how much is the difference? Correct. We can't say prevailing rate. As prevailed in the year 2000. Because they have given you the representation. Correct. When was the allotment given to shop number 69? As per that, so as per the terms of shop number 60. If you say anything, you are harassing them in one way or the other, right? Yes. What is that? Within a period of 4 weeks from the date of release. From the date of 8 weeks from the date of release of this. Letter received from the party, Who has written this letter? See, your client has written a letter. Into that. What is this filing of paper book? Is it necessary? Filing of paper book is dispensed with. Please the matter for final hearing. Is immediately after Dasara vacation in the week commencing from 21st. Look into that letter. See, you have been representing them. Yes. Yes, Mr. Venkata Subbarao. Venkat Subbarao. You do not want to press this petition. Please. Withdrawal is filed by the appellant. States are under review of the memo file. The appeal is dismissed as not pressed. Yes, Mr. Prabhakar. Memo is filed by the appellant seeking to withdraw the appeal. The memo reads as under. Is it admitted? Admit Aguila. In light of the memo file, the appeal is dismissed as withdrawn. As the appeal is not yet admitted, the appellant is entitled for refund of court fee. As per section 64, 66 of the Court Fee and Retaliation Act in accordance with. Yaar obne appellant, appellant. Huh? Not your client. When the counsel for the appellant submits that
My lord, serial number 6. I represent the
in the course of the day has been paid, office to verify and proceed. Yes. Hmm. In which matter you have filed? Learned counsel for the appellant submits that the paper books have been filed in RSA 2652 of 2017 and the filing of paper books to be dispensed in the present appeal in RSA 56. The such submission is recorded. That is complete, right? The such submission is recorded. Filing of paper book in RSA 2655 of 2017 is dispensed with. Yes. R? Where is it? Where does it? No, R9 notice is not served. How many times it has been issued? How many times? N number of times means you have paid process now for respondent number 9, right? Now this is for the third time. So until you take notice for the thrice, you cannot seek a paper publication. Is it not?
respondent number 1 in this matter,
Yes.
and I have filed my paper books in this matter and served a copy on the appellant also. But its only request is let it be listed immediately after service of notice on the respondent numbers 8 and 9.
8 and 9 in this.
In the subsequent appeal 6.1, it is regarding.
This matters immediately after service of notice.
I'm grateful, Manoj.
The only dispute is that I'm an IT company. They say not that company is to be built under HD2B, this commercial type. They pass on the project range. This honorable court in identical situation has not held that the activity not involves a 126 application. Before that, Lord, may I proceed your lordship? In 2011 itself, same kind of demand was raised.
This had, we have heard this matter earlier in the, no. Yes, what you say regarding this? No, they say the petition is fairly covered by the decision of the coordinate bench of this court. What do you say regarding that, Judge? Okay, Dera. We will place this.
Yes. Already one order is passed in 19, page 61. But you can see the operative portion. At page 61, Lord, the order begins. Same kind of dispute. HD2A Rebecca, 2B Rebecca. Lordships may see Lord 67. This also, Lord, the other side may kindly be directed to. Provident has also stated. Page 67, am I reading with you?
Yes.
Was inspected.
Kindly look into this also, para
67. And also next order, Lord, of page.
Just note down this. Mr. Counsel.
2016 order also,
Counsel?
page 79. This also, order at page 18. Literally, further the said CJ was not, sorry, the bill of installation of so and so, HD2A tariff only at page 18. Direction number 3. ಇದೆಲ್ಲ ಆದ್ಮೇಲೆ ಮತ್ತೆ that demand notice at page 81 is issued. What the CTRF has already held, my lord, if you have not challenged the earlier order, final order is passed. This is assessment order only, page 79. There is no provision for passing one more provisional order. Already this order has attained finality. And they say that you have not challenged the CTRF order, it has attained finality and does not call for any revisit or interference. But if you the interim order is there, and protected.
It's an interim order.
Yes, but there was no urgency also in this. Instead of that matter, this matter was thank God.
Yes.
But not only the matter is covered by a coordinate, their own orders, 2 orders are very straight. In fairness, not lordship.
The office objections have been complied. When it comes for the petitioner submits that the office objections have been rectified. Office to verify and proceed. The Learned Counsel for the petitioner placed the decision of the coordinate bench of this court in VPS PF AIR Systems Private Limited versus Assistant Executive Engineer in WP, passed in WP 17593 of 2024 and connected matters disposed on 25th July 2024 and submit that the petition is fairly covered by the decision of the coordinate bench of this court. Then a counsel for the respondent at this stage seeks to look into the decision. Yes, I request list this matter. If it is covered, you just tell whether it is covered.
And H and J also not.
No, we need not tell this. Yes. Okay. Is this matter on Monday? Interim order granted earlier is extended till the next date. Look at it then. Too much time for today. Further extension of time is not by the district judge. Two weeks, 2 months time.
Much of it.
Paragraph number 10.
We need to comply with it. Petitioner to comply the office objections. Office to verify and proceed. What is this? This is the representation, huh? Annexure C. What is Annexure C? For in pertaining to what?
Pertaining to a circular has been issued. After the Supreme Court order, they have to go back to the earlier phase if the places are available. Regarding that, only for lending license, the permission has been.
If it is too not even visible to the eyes, you produce at least the typography of this. If you want to place reliance on that. You don't want to place reliance on this Annexure C?
That is the only circular issue to other licenses. I am speaking that.
You want it on parity, right? You want on parity, right?
They say only 9 licenses. It is apart from 9 licenses.
So this is what license now?
CL?
CL9. So that is
not getting proper business at the present time. Hence he is seeking for the earlier place.
Delhi.
That is not allowed.
Hospital pakka na.
No, it is not.
Where do you want? You consider the representation. Who is respondent number 3? And he is the competent authority to consider the representation. And yeah. So you give a representation to let them give the petitioner. Yes. SCGP to accept notice for respondents. Learned counsel for the petitioner submits that a representation at Annexure D has been submitted to Excise Commissioner, Karnataka Government, Bangalore. And Karnataka, Bangalore. The petitioner is seeking for a mandamus, directing the respondent number 3 to Deputy Commissioner Mandya to consider the representation filed by the petitioner. As could be seen, the petitioner has given representation not to the authority, that is respondent number 3. Such circumstances as brought to the notice of this court by the learned SCGP. In such circumstances, the petitioner to file the appropriate filed representation to the respondent number 3, and on such representation being submitted, the respondent number 3 to consider the representation of the petitioner in accordance with law with an outer limit of 4 weeks from the date of filing of representation. Office objections overruled. Submission accepted. Submission overruled.
Serial number 11, my lord, appearing for respondent, my lord.
So with 1A.
They filed for application for recalling the order dated 1/8/2024, my lord. May be allowed, my lord. Yeah,
Paper
no.
book filed, my dear. ಅಲ್ಲ ರೆಡಿ ಇಟ್ಕೊಂಡು ಬರಬೇಕು ಬಂದ್ಮೇಲೆ ಹೇಳ್ಬೇಕು ಕರೆಕ್ಟ್ ಬಿಕಾಸ್ ಅರ್ಲಿಯರ್ ಡಿಸ್ಮಿಸಲ್ ಇತ್ತಲ್ಲ ವಿ ಹ್ಯಾಡ್ ನಥಿಂಗ್ The 1 of 2024 is filed to recall the order dated 1/8/2024. Reason stated is accepted. Order dated 1/8/2024 is recalled, subject to the appellant filing paper books within 2 weeks. Then you should do it immediately, Alva.
Much obliged, my lord.
Yes, Mr. Gangadharappa. Yes, yes. Here, madam. Possession suit. Or partition suit. Pass over. Under section 3(2), no, only petitioners, all the petitioners want to withdraw, right? So the other petitioners are. Others have already withdrawn, right? By order dated?
Different dates stated in the order. You wanted a context. Others like they are taking it.
Settle ಆಗಿದೆ ಅದು. ಕೊಡಿ act ಕೊಡಿ. This is under the KVO Act, Village Authority. He has to go before the Deputy Commissioner. Order of Deputy Commissioner. Now Deputy, correct. Now the order is passed by the Deputy Commissioner.
Order is passed by the master.
Then against the order of Tahsildar, it is to the district judge. Section 3(2). But then what was there before the, this says powers of deputy commissioner to decide certain questions. So you don't, you say that an appeal is provided, right? Yes. When a counsel for the petitioner number 4 seeks to withdraw the petition with liberty to file appeal as envisaged under section 3 subclause 2 of the Karnataka Village Offices Abolition Act 1965. Stop. The said submission is recorded. The petitioner is permitted to withdraw the petition number 4, with liberty to approach the appropriate court in accordance with law. It is needless to observe that the time spent before this court is available for the petitioner under section 14 of the limitation. Is the order?
Eight, 836.
How many writ petitions? 3.
Three. For 3 different areas.
Just a moment. All separate orders or one order is? First writ petition?
27 September. It's a process in the word side of the 3 cases. 27 September 2023. I have another copy.
Yes, kindly finish. Yes.
First one is 836. That based the period 1 from 17 to 18.
Yes.
Then 18 this period is also 18. And 1819. 19 all relating to damages injury.
Yes. Yes. Now, in light of the decision of this court, these orders have to go.
The light of the decision law holds that this classification of international workers is constitutional. This in case here not used, we have not taken certain employees as international workers. And then we internally not did some exercise and we thought we should err on the safe side. So we calculated and paid the contribution. The proceeding before they could issue any notice. The proceeding from which this matter arises notice, they enforce penalty and penalty. So we contested it to say that there is no deliberate intention. But the thing, orders are passed, demanding equal amount of penalty plus interest on that. That is what is challenged. Yes. Quoting the order law is challenged. Interest on the original contribution has been paid by us.
In light of this order, you are not entitled to even seek for this penalty or damages, right? Correct. That is all consequential orders, right? 14B is all consequential orders. So once we hold that the para 83 of the Employees Provident Fund is unconstitutional and you are not entitled to claim anything from the employers who are the international workers, then what survives now? Yes. Here is the question of imposing any penalty when the main itself does not arise. Is it not? Yes. We want to set aside. We want to only set aside 14B. Correct.
That's not
No, correct. No, 7Q doesn't arise here, right? It's only 14D, right? Petitioners will pass separate orders or common order? One order will. Only will say the period for which the claim is made. Yes. The petitioner in WP 8836 of 2021 is seeking for the following claims. WP. More WP. The petitioner is WP 8836 of 2021. The period of claim made by the respondent number 1 is from 1/4/2017 to 31/3/2018. And the period of claim made in comma photo and the period of claim made in WP 88 of 2021 is from 1/4/2018 to 31/3/2019. And WP 8819 of 2021 is in respect of 1/4/2000 claim of the year 1/4/2019 to 31/3/2020. The learned senior counsel appearing for the petitioner placed reliance on the decision of this court in WP 18486 of 2012 and connected to the petition. The case of Stonehill Education Foundation and others versus Union of India and others disposed on 25th April 2024. Would contain that in light of the sucking down of para 83 of the Employees Provident Fund and para 43A of the Employees Pension Scheme being struck down as unconstitutional and arbitrary. The orders, the impugned orders passed by the respondent number 1 needs to be set aside. Yes, we'll see that. Learned counsel for the respondent authority submits that against the order passed by this court in the Stonehill Education Foundation, the appeal has been made. Eight 887 887 of 2024 has been preferred before the division bench of this court, and the matter is pending consideration. It is relevant to note that there is no interim order granted by the granted in the above mentioned writ appeal. No, there is no interim order.
Yesterday.
No.
Interim order.
But correct, it was heard, right? It was posted before the correct. See, fact remains that there is no interim order. Fact remains that there is no interim order granted by the division bench in writ appeal 2024, staying the operation and execution of the writ petition order passed by this court in the said circumstances. The impugned orders passed by the respondent needs to be set aside, and this court passed the following order. The writ petition is allowed. The order dated the dates wherever the order passed by the respondent number 1. Annexure A is set aside. Set aside. Any liberty to be granted in the case of
Only one sentence in the not appropriate. These petitions are confined only to levy of damages in the 14B. Since the main challenge is succeeded, 14B question may not, penalty would not be, the damages would not be.
In the present case, as the petitioner has questioned the levy of penalty.
Or damages, sorry.
Penalty, bad damages. Damages under section 14B. 14B of the Act 14. Applies Provident Fund. 14B of the Employees Provident Fund. And in light of the light of coding that introduction of para 83 of the Employees Provident Fund scheme and 43A of the Employees Pension Scheme as unconstitutional. The levying or recovering of damages, which is a consequential order, would not arise. Consequential orders, right? Consequential orders, right? Consequential orders would not arise. Accordingly, this court passed the following order. The levying of damages, the levying of damages to the petitioner by respondent number 1 as annexure A is set aside.
The damages in the consequential interest.
Correct, and consequential interest. So it all follows, right? Consequential orders. The impleading applicant who has filed this impleading application to implead whom? The owner. So notice has to go on that, right? When was the notice issued? He is the owner. So we will allow that application. I-1 of 2021 was filed to implead the respondent number 3 in the present proceedings. Respondent number 3 is served and represented by counsel. But this is the owner on whose behest you have disconnected their electricity. No. Now the Mr. Devraju, this respondent number 3 is the owner of the premises. So he's a necessary party, right? The respondent number 3 is the owner of the petition premises. He is just a necessary party to the proceedings. And accordingly, I number 1 of 2024 for impleading is allowed. It's petitioner to amend the cost title and file amended cost. What is this amendment about? It is what is petitioner to learned counsel for the respondent submits that I-2 of 2024 is not served. Petitioner to serve the petition paper I-24 for the learned counsel. Yes. What is the interim order? Application is for including the interim prayer. The main prayer it should have been done at the first instance. See, immediately you see the thing is when you are not diligent in filing a writ petition with all these prayers, You should have sought that interim period in the first instance itself, right? Yes. You provide them with the electricity. What is the suit for? Already, tenant landlord dispute irude. See, that doesn't mean you can disconnect the electricity supply.
Only the sanction, when the sanction was there, they have filed an objection to not.
Where is the respondent now? See, they are staying in the premises.
I'm not aware of.
See, even have you challenged that suit? Then no, dispute is there, owner can't object for power supply. As an interim relief, we will grant them, so you will direct you not to take any coercive steps. Then what is that? In the electricity kottilla, they say they have not been provided, it's one and the same way. Ah.
After service sanctioning, there was an objection from the owner side that the pending that we have not serviced the installation. By that time, that he has not disclosed the hospital in the inspection as far as it is the manner to provide for the action. But after inquiring that the purchase of the objection.
Earlier, there was a sanction in favor of the petitioner, correct? The proceedings were initiated by the landlord. The eviction is ordered against the petitioner. They have preferred an appeal. They have not been evicted from the premises. This is one type of harassment. Then why are you not providing sanction? Then provide electricity to them. Sanction court mele sumne idre, it is as good as not providing electricity. You after giving sanction, you have to provide electricity. So we will say direct you to provide electricity. What is Annexure C? Yes. In IA2 then. We will allow that IA2. IA2 of 2024 is filed for amendment of the prayer. What are you seeking amendment? Madam? You writ petition copy ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ amendment ನಲ್ಲಿ. Amendment is only amendment. To incorporate the grounds for interim prayer and interim prayer. The application made by the petitioner seeking amendment is allowed as the petitioner wants for consideration. The petitioner is insisting for the interim. The reasons indicated is accepted. I2 of 2024 is allowed. Petitioner to amend the writ petition papers and find amended copy of the writ. The petitioner, Learned Counsel for the petitioner submits that pursuant to the sanctions made by the respondent at Annexure C, they are not providing electricity connection to the premises. Learned Counsel submits that the petitioner asserts that the petitioner is residing in the said premises, as providing of electricity connection is the basic community of a person who is of a citizen. With that circumstance, the respondent is directed to provide electric connection to the premises in light of the sanction order at Annexure C and the petitioner paying consumption charges. By following the prescribed fee. Prescribed fee. Yes.
Considered for the major withdraw, received compensation, but not has obtained not to draw. In fact, not foundation for the tower is very stand.
Yes, that was the, that was what mentioned by the petitioner before this court.
But in British part, you have not disclosed. In fact, not he points out.
See, you had already received compensation.
Documents along with negative statement. I have to argue. But I expect one week facts. But the document was already instead of.
Just a minute, one nimisha. Let us see what they have produced.
Kindly have a look at page 38. One of the IL.
The contention taken in the earlier repetition also, there is a direction given. Right, disposing of the earlier repetition also, where a direction given.
Yes, let us see.
But he is not in 39. What is it? The petitioner, the second petition authorizes the first petition to receive the compensation. Saying that she is staying in Bombay. Then have a look at
The petitioner is the wife of this Gopal Munnappa Pujari? No.
Yes, all the regulars.
So she has taken the compensation on behalf of this Gopal Pujari.
Yes, but also see then there are conditions not approved documents. Page 41 has gone back on 23/7/2023.
When was this compensation taken?
But I think first blood addition of the documents in order. 23/7/2023, not at page 41. We have issued the notice asking for their consent, not stating that we will be drawing the line. But at the bottom of the lordship, she kindly acknowledge and countersign the receipt of this notice. Should carry your consent receipt construction at the bottom. That is being signed. Then you also have page 44, which is the NOC.
Yes, just a minute.
Yes. At para 5 and 6 months, at page 44, they again consent. The different comes from para 5, the different comes from whatever the compensation district commissioner or any Supreme Court, but we went directly in favor of our accounts sponsor, Gopal Munnappa first petitioner. The different related that she will not call the interface the executive of tower installation, who is speaking in further operator of transmission line. This is not as of 23rd July 2023. Then you have to find out there is a damage assessment which is there at page 47. Then you also have a look at page 51 where there is an agreement which is signed. Then it is pointed out that how the compensation will be paid. But to just see page 51 right at half page. I also have no objection if it will be because of a transmission line. If the agent contractor has to carry out the work of foundation, selection of towers, to the contractor, major activities so on so also. The payment should remain as per the below mentioned criteria. That is the company of 3 different activities in different stages. Foundation arrangement 40%, 30%, 20%. Then Lord, you also see this is also signed by him. Then you also have a look at page 52. Where one tranche is received on 15 May 2023. I, Gopal Munnappa Pujari, certified that I have received the thanks from Unity Passport for 11 lakh certificate. But it number so on, dated so on, issue number. Then you also cannot have a look at the bottom of the page.
Yes.
The calculation for land improvement has been made on the basis of tower base and corridor area, measured in my presence into my satisfaction and I hope that this is direct. They were expecting properly local language also, we are signing this. The check note is managed product at page 53, which has been issued to me. Then you also have a look at page 54. One more receipt for a separate sum of 8,24,401. Not the check is enclosed at page 55. But there is a report from the Deputy Director of Horticulture at election RA page 56.
You have paid separate amount for
This is for the trees which are paid. That's what you also see the same figure at page 56 and 57. The Horticulture Department assessment it says 8 lakh 24 at page 57. You have to find figure. But we have paid, this is the figure not you have to find. The check is issued at page 55. Which is issued. Then what you have to turn to page 115. This is in 2023. Not in 2024 also not he receives. The further figure not.
yes.
But now what you see in the entire petition. He addresses this. In fact, what you now takes the order not was passed in the earlier one, not at page 78, not what just have a look at not really. He has filed a petition. You have to find out that WP number 15989, not you have to find this back at page not 102. Along with a series of petitions, but several persons had filed petitions.
Yes.
Then you also cannot have a look at page 104.
Yes.
The petitions are agreed with respect to endorsement issued by so and so, Deputy Commissioner for so and so. And petitions the direct response not to draw high attention where lines of consideration because their corresponding plan. This court has passed series of internal motion in compliance of authority of complete the right report of information all the right of the parties. But when you turn to not para 3 not at page 105. If you want to run council's petitions authorized, it could be that some of the petitions have signed consent forms and received compensation as a part of the one so for the respondent based on money. So but other petitioners, there must be liberty to file. But there are several petitioners, some of them have received, others have not received. Therefore, these request of great liberty must be reserved to others to make a representation. And accordingly, kindly have to get para 508 the transmitting company is ultimately using any portion of the speech block is identified as they will be entitled to compensation as per the law. And on page 107, 108, liberty was given to make representation to those other petitioners who have not received compensation. And on or before 10/11/2023, for those petitioners, this petitioner did not take any representation before that date. Obviously, not because they have received compensation. In fact, his representation is I need more compensation because according to me, what is damaged is oil palm trees, which are according to the value price. Those are matters not under section 16 of the legal have to go to the district that are not dissatisfied. Now, what you see the petition, he makes a wrong statement, not one more wrong statement. I have the petition which he has filed now. Then he says the whole basis not he has made a challenge by an order of the DC. The passed earlier, dated 18/10/2022, that is the prayer order at page 28. And the government order which he has made in para 8 is that he was not knowing this order at all when he filed the earlier petition, which is completely incorrect because in his earlier petition, page para 8 not in his petition.
Question, what was the order under challenge in the connected in the earlier round of litigation?
I have not.
Earlier petition, my lord, there is a CCTV direction against the DC. We have to conduct an inquiry under the Telegraph Act after hearing all the accused parties because there are no inquiries.
By then there was an order passed by the Deputy
Yes,
Commissioner.
which he referred to there in the petition. Now, not in this petition, see para 8, he says I was not having knowledge of the order. In fact, I extracted in my IA, my IA itself, I extracted the paragraph of the petition. At the page para 3 of my IA, I have extracted para 3 and 19 of the earlier petition. Not earlier, it was not in this particular copy, he did not file a copy of the petition. He very much refers to the 18/10/2022 order. Now, in this petition in para 8, he says I did not have knowledge of the order at all earlier. And what he acknowledges there in the earlier petition, yes, some of the petitioners have received compensation for others to reserve liberty. Now, not by suppressing this fact that he has received compensation, but if he has any grievance regarding compensation, I have not. In fact, this very project was challenged by some others who not before this on the court. And went to the division bench upheld the project. Said if you have got any grievance for compensation, but ultimately it's only a right of use which is being taken. But and I have already fixed the foundation for the covers. Now not compensation not is public interest would be affected, but
Yes. This is all, this facts are, you are aware about it.
My learned senior friend was all those there is some suppression of facts, everything. All these very same argument was canvassed in early repetition. Previous bench cannot, same arguments was canvassed, simply that cannot, that has been done, this has been followed, that has been. Taking into all those considerations, there also may not bring out the maintenance of status quo, vacancy application was filed, that has been heard by report. And when you look at the prayer of 108 May, so that is why I will make submission now, subsequent developments has been taken place. Now the yours will really see. This is the direction, clear cut direction. My learner is there, it is for some other person, not for this person. When you look at 108 May. The vacancy application order, 108. The concerned deputy commissioner shall, after considering the representation, supplication, including any material that may be placed on record as regards the consent form, fine and the compensation received by the petitioner. He cannot exclude me that I am not the person concerned. And decided on the representation on.
Your submission was certain petitioners who have already received
I
compensation.
never said that, well, I am not any.
This is your argument before the single judge, stating that you have received, certain petitioners have received
I did not
compensation.
suppress that I have not received. Before the earlier break. Now may not when.
Then you made a submission that certain petitioners have not received compensation. Insofar as those petitioners who have not received compensation, please grant me a liberty to make a necessary representation, and the said representation to be considered. That is the order which is being found.
This person never had a anything on this. I made election, yes, maybe really see.
Where is the liberty granted to you to give, even if you have given representation, where was the liberty given to you in the?
Yes, I am the one. Place direction is given to say that whatever the offense is,
This fact should have been brought to the notice of this court.
I got the Lord.
Where was it? Where did you say in the petition? Did you say anything? Yes.
Annexure H, my petition, page 80. When you look at my petition, annexure 18, page 8. Let the government produce the document.
Now you dispute that checks which you have received now.
Who dispute that?
Then-
That is why
Then how is this split petition maintainable?
So what is the application has been submitted in compliance of the court order dated by 23/11/2023.
It was not available to you.
There is a direction to dispose of the matter on or before 8/12/2023. My representation was made before the deputy
There was
commissioner.
no liberty granted to the petitioner.
What is the prayer mail? I am a party to the petition. Shall, after considering the representation application so far, does not exclude by me. It does not exclude me. But when you look at this, based on record as regards the consent form signed and the compensation received by the petitioners, that includes me also. I have to place it before the deputy commissioner. So far as these items of damages are concerned, my lord, I have to receive the compensation.
If, according to you, the compensation which they have given is not, go to the civil court.
This is not produced by the other side. When you look at this, for the installation of the UKC project, I hereby finalize. One, the land value so and so and so and so. The important is made further additional compensation for the land.
Then if you are in, if you want.
My proceedings. My proceedings, it's further development after the order was withdrawn before. So I have to place this document before this lordship consideration. These documents are vital documents. I am the land user. Well, palm oil trees, plantation, they ransack the property.
When you take a compensation from an account,
That is not decided. No, that is
how is this petition maintainable before this court for enhancement of compensation? If at all your grievance is, this order was passed in light of your submission, that there was, the compensation has not been determined, there was no valuation. You did not even whisper about the compensation being paid to you on the earlier occasion, that is in the year 2023 itself. If at all you had made a submission to the court that you had received compensation and the petition and it was not an adequate compensation, then we would have directed you to go to the civil court.
That is why when the court was.
How is this petition maintainable before this court?
When the court was reached to observe, that kind of additional compensation, whatever the compensation which has the risk, that has been paid before the
Correct.
DC.
You go and seek for enhancement, you can't stall the proceedings, that's all.
Account of the direction given by the farm. Well, let the government produce the document.
Let them do whatever they want, you get compensation.
Complaints of this order. Where is the complaints of this
See,
order?
you want to stall, you want
Let
to,
them produce the order.
we will vacate, or you want the court to dismiss your petition. Either or.
Some subsequent development document that I need to.
Not necessary in this petition. No, second, this court won't sit.
Appreciate this, my lord. When may not be, I having the subsequent document, my lord, I have to place it before your lordship's consideration. Well, just because when the vacating the application, I cannot be.
We appreciate your efforts, Mr. Acharya. Correct, we understand.
Is lost. Well, I.
Land losers also should be fair enough to the court, right?
My lord, that is why the court was pleased to
If
observe.
at all you want enhancement,
Well,
you can approach
your
the
lordship is not coming to my rescue.
We came to your rescue by giving an interim order, now there.
Observation by the court, well, I want to place Mr. Lordship this submission, well, in compliance of the earlier order.
That is not available for this court to look into. ಅಷ್ಟೇ ಇರೋದು.
My lord, your lordship, kindly appreciate this, my lord. Kindly permit me to produce the documents. I want to have input there. They are produced properly. At least may I have the liberty to counter this, my document produced with others. Well, I am having the liberty
You
to
want this court to pass orders on the merits of your petition? We will dismiss with cost. Where is that necessary in this petition when you have already received compensation? Your materials, what you want to produce is pertaining to the compensation which you want to receive by way of enhancement. That would have to go to the civil court. That is not before this court.
That is the direction you give by this court.
We will consider that. Again, direction ittu anta helidre, that would affect your representation also. In the event, Mr. Acharya, in the event this court holds that there was no direction for you to give a representation, and in the guise of that order which was given to certain other petitioners, you have filed a representation, we will say that your representation also could not be considered by that. Agbidattalla.
At least you also come to my rescue from the reason where
Court
I have
rescue.
submitted the representation. Next page.
We will vacate the interim order. We'll tell them to look into whether they can be a grant compensation.
DC has to look into this.
DC will see whether
They have to protect that.
let the DC consider their. We will vacate. But anyway, that would not be the scope of this writ petition anyway. Now this is the now
Hearings also.
inherent to double.
ಒಬ್ಬ ರೈತ ಅವ ಬೆವರಿಸಿ ಒಂದು ಕಷ್ಟಪಟ್ಟು ಮಾಡಿದ್ದನು ಈ ಪ್ರಾಜೆಕ್ಟ್ ಅವರು ಬಂದ್ಕೊಂಡು
When you take the compensation, correct, ಆ ಟೈಮಿಗೆ ಬರ್ಬೇಕಾಗಿತ್ತು. We understand, Mr. Acharya.
ಪ್ರಾಜೆಕ್ಟ್ ಅವ್ರಿಗೆ ಏನು ಈ ಜೆಸಿಬಿ ತರ್ತಾರೆ ಎಲ್ಲ ಹೋಗ್ಬಿಡ್ತಾರೆ. ಪ್ರಯತ್ನಿಸಬೇಕು ಬೆವರು ಹನಿ ರಕ್ತ ಸುತ್ತ ಮಾಡ್ತಿರ್ತಾರೆ ರೈತ ಇವರು
Before a wrong forum, Mr.
projects is also I have planted. Our pepper plantation your calculation ಮಾಡಿ ನಾನು ಡಿಸಿ ಹತ್ರ ಬಾಗಿಲಿಗೆ ಹೋಗಿ ಬರ್ಕೋತಾ ಇದ್ದೀನಿ ಇದನ್ನ ಸ್ವಲ್ಪ ಮಾಡಿ ಅಂತ ಕೊಡು ಡಿಸಿ ಅವರು ಸ್ಪಾಟಿಗೆ ಬಂದ್ರು ಮಾಹಿತಿ ಮಾಡಿದ್ರು ಒಂದೇ ಒಂದು ಮಾಹಿತಿ ರಿಪೋರ್ಟ್ ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ನಾನು ನೋಡ್ತೇನೆ ನಾನು ಆರ್ಡರ್ ಪಾಸ್ ಮಾಡ್ತೀನಿ ಈ ತರ ಮಾಡಿದ್ದೀನಿ ಕಾಂಪನ್ಸೇಷನ್ ಯಾವ್ದಕ್ಕೆ ಮಾಡಿದ್ದೀನಿ ಲಾಸಿಂಗ್ ಮಾಡಿದ್ದೀನಿ ಲ್ಯಾಂಡ್ ಕಾಂಪನ್ಸೇಷನ್ ಮಾಡಿದ್ರೆ ಕ್ರಾಪ್ಸ್
ಟ್ರೀಗೆ ಕೊಟ್ಟಿದ್ದಾರಲ್ವಾ? ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರೆ can you are disputing the documents. You can't overlook the documents which have been produced. What is this, Mr. Acharya? We thought you were genuine. To what extent? ಅಂದ್ರೆ ಏನು ಹಂಗೆ ಇರೋದು after receiving all the compensation still you want to
now Now one more submission.
ನಿಮ್ದು
One more submission.
you still
Yesterday,
can
my lord,
use, you can still use your land for other crops. It is not that you cannot use it.
Well, yesterday, my lord, there is one more writ petition filed by the company that is 2296 2024, it came up before the court on number 50. With regard to the same issue, with regard to that, they are facing many kind of obstructions there. The government representing the deputy was stating that there is a direction by this court as per that.
Correct. That is available to certain petitioners, not you.
No. It is the company itself is the petitioner before that court. That the DC is taking the convention, stating that there is a direction by this court. We have to conduct an inquiry. Ali ಆತರ ಹೇಳ್ತಾರೆ. It does not vary, but it is a petition filed by the company itself. Well, kindly protect my interest so far as my given information, because may not lots of the damages caused by the company to the plantation crop. Palm oil plantation crop, that is not enter. Now, they are the kindly see. But this is the document which they have seen possibly. Well, may pass it on me.
ಯಾವುದು ಬೇಡ.
ಅಲ್ಲ, may pass it on me. These are not looked into, my lord. Because now ಮಾಡಿದರೆ, this is ordered by the DC. Kindly look at the paragraph 3. These are all process, my lord. These are all process. When I'm just in the course of a day, they shall not be damage to the property like lands and property like this. Kindly look at this. All movement. ಅಲ್ಲ, ನನಗೆ ಪ್ರೊಟೆಕ್ಷನ್ ಬಗ್ಗೆ ನಾವು ಏನಾದ್ರು ನೋಡ್ಬೇಕು. Kindly look at this. This is not yet finalized. This is by the DC himself. That is why I said I have produced this document. Some hardship is caused to the agriculturist, my lord. I have to.
That is pertaining to the petitioners who had not received compensation in that writ petition. How is it concerned with you? ನೀವು ಇನ್ನೊಬ್ಬರಿಗೆ ಕೊಡ್ತಾರೆ, ನನ್ಗೀಗ ಇವ್ರಿಗೆ ನನ್ಗಿಂತ ಜಾಸ್ತಿ ಅವ್ರು ಕೊಡ್ತಾರೆ, ಅದಕ್ಕೆ ನನಗೂ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಅವ್ರ ಮುಂದೆ. We can talk. We will dispose of the writ petition itself.
I'll place the document. You know, I have not used it. I'll place the document for your last consideration. There is no hurry for this thing because their company itself are before this court. There is no hurry for vacating the interim because he's a connected writ petition. They are before.
We will dispose of the writ petition itself. We'll direct them to consider. ನೀವು writ petition ನಿಮ್ದು opportunity.
Non-compliance of the order. There is direction given by this. It is not complaint. At least that way there is a direction by when the case is complained or not. Let them be document be produced by the government.
Let the writ petition be pending. We will vacate it. Yes, sure. Others on immunity of the respondent filed this application seeking to vacate the interim order granted by this court on 13/8/2024. Third, the learned counsel for the petitioner and learned senior counsel appearing for respondent number 2. Then senior counsel appearing for the respondent number 2 draws the attention of this court to annexure R2 to R7
Not the last one, but
and annexure R12 to
R8 number is articles.
R2 to R8.
Yes, R8 and R12.
R2 to R8 and R12. It submits that on 23/7/2023, notice was issued under the Act to the petitioner for obtaining their consent for construction of the transmission line and for payment of compensation for the damage caused. On receipt of notice for consent of the petitioner, no objection certificate dated 23/7/2023 was issued by the petitioner number 1 for herself, for him acting also on behalf on himself and on behalf of petitioner number 2, confirming that the parts of the lands of the petitioner would be used for installation of tower, stringing of wires. This submitted by the petitioner confirmed to receipt of compensation as be fixed by the competent authority for utilization of the land, and undertook that they would not cause any interference to the execution of the power installation, including stringing and further operation of transmission lines. This being so, an agreement was entered into the parties, between the parties, as between the parties, and a compensation for land and of fees in terms of the order issued by the DC, and the petitioner were paid compensation amounting to rupees 11,75,306 by way of a demand draft dated 17/8/2023 towards 40% of the compensation payable for foundation works at the petitioner's lands, which was completed subsequently on 12/10/2023, and an amount of rupees 8,24,401 was paid to the petitioner by way of demand draft dated 25/8/2023 for the crops bar trees as per the noted comma horticulture crop Malki valuation report noted comma of the Department of Horticulture, which was communicated corresponding number 2 applicant by a letter dated 4/8/2023. When senior counsel submits that the petitioner understood and undertook that the compensation was against the land used for tower, base, and corridor during the construction of the aforementioned transmission line over the petition land by the respondent number 2. Submitted. Where is that?
Page 115. Letter to page 118.
118 page.
Page 118.
What is the connection?
But that is part of not a picture article.
Okay.
That is 2027. He issues total sum of about 1,70,223. He says that is only too much damage to borehole and pipes.
When the senior counsel submits that in addition to the compensation received by the petitioner, as stated above, in respect of some damage to the electric cable, borewell, irrigation pipes, etc., during the construction or erection of towers at the scheduled land in question, the petitioners were paid an additional amount of rupees 1,17,221. And the compensation was received by the petitioner, no doubt, under protest. Learned senior counsel submits that the petitioner, having received the compensation fixed in terms of the order of the Deputy Commissioner dated 27/10/2020, has forfeited.
Not paid as per not on that order. Subsequent order is passed. Financing the farmer not seeing 4 times paying value. Not you are paid as per that.
Which is that order?
That's not a.
Order dated dash Shantar order. That,
109 you have produced 15.20.
15th month,
2023.
as compensation fixed in terms of the order dated 15th month, 2023.
Document runs counter to it. That is
Petitioner.
sufficient.
Document runs counter.
ಅದು ನಿಮ್ಮ submission ಗೆ ಹೇಳ್ತೇವೆ.
Acceptance ಮಾಡಿದಾಗ their own documents runs counter to that submission.
And that the petitioner have forfeited the right seeking further compensation. The Learned Senior Counsel submits that in light of the interim order granted by this court, the present public infrastructure has been stalled, and the progressing and there is obstructing of the progress of work, the interest of the public at large. So, consult the Learned Counsel for the petitioner submits. ಹೇಳಿ ನಿಮ್ದೇನು first?
What is the complaints of the earlier court or you cannot apply by the DC?
One ನಿಮಿಷ. Senior counsel for the subjects that in the earlier round of litigation, wherein the petitioner had approached this court in WP 15989 of 2023, seeking for keeping a direction to the respondents from drawing the high tension wire lines and construction of high tension power towers in and around the Schedule 9 of the petitioners for their intended 400 kV RPC, and directing the respondent number 1 to initiate the proceedings as per law or conduct the inquiry with respect of the usage of land by respondent number 2 and 3, and to issue as per the law under the Telegraph Act. Learned Counsel submits that the petitioner specifically mentioned about the order or proceedings dated 18/10/2022 of the Deputy Commissioner, directing fixation of compensation at different dates, and taking into consideration the nature of land in question. And would submit that perusal of the earlier writ petition clearly indicates that the petitioner had knowledge of the order dated 18/10/2022 passed by the Deputy Commissioner.
All these facts have been suppressed.
And the said facts have been suppressed by the petitioner in the instant proceedings. Or counter the Learned Counsel for the petitioner would permanently contain one though.
The earlier order passed with this court, my lord, directing the DC melody is not complained. We conduct an inquiry, authorized.
Learned Counsel would urge the following ground that the earlier order in WP 1589 of 2023, the respondent, Deputy Commissioner Alva. Now, Deputy Commissioner has not considered Alva.
There is no conduct an inquiry at all.
The Deputy Commissioner has not complied the orders passed by this court, by the coordinate bench. Next, Inando.
With regard to the representation submitted of annexure H melody in compliance of the direction given by this court by me has been submitted before the DC as per annexure next page 18. where
That
I have mentioned about the acceptance of the compensation earlier received, and then I have stated that what are all the subsequent damages which has been caused, that was not gone into by the reason. So there is no question of suppression of fact is my subject.
as the representation submitted by
Annexure H.
the petitioner at Annexure H,
It has been accepted by the reason.
pursuant to the order passed by this court in WP 15989 of 2023.
The top caption notice I mentioned, letter from High Court. That means this order from High Court, I mentioned.
So that exhibit I
Annexure H may not page 80 to the report. Where my lord I have made the calculation with regard to which is, those are all the matters which needs to be gone into, which is not done by either by the company or not by the reason.
It's not considered, right?
Yes.
It's not been considered by the deputy commissioner.
And no notice of inquiry is
The
ordered.
laying of line by the respondent without consideration of considering the representation of the
And so also made annexure R page
petitioner is
110.
entitled for continuing of the order granted.
So also annexure R. So also annexure R.
Annexure H as well as
R subsequently I have made. Annexure R page 110.
as well as annexure H and as
Annexure R.
annexure H as well as annexure R.
R.
Ashtena?
This.
This court has heard the learned counsel appearing for the parties and introduced the material. It is not in dispute that writ petition 1589 of 2023 was preferred by the petitioner with the following prayers, page 3 of the vacating. Vacating my
Document for the assistance of the court.
way diagram.
ಅದು ಬೇಕು ಇದು ಯಾಕಂದ್ರೆ it goes to the
We
root.
will send you.
ಇದರ ಆಮೇಲೆ ನನಗೆ ಫೇವರ್ ಆಗಿ ಬರುತ್ತಿದೆ. So that has to be gone into by this court.
The grievance of the.
I may pass it on.
The petition pending is avak kodi. You can give all the documents. The grievance of the petitioner was regarding the failure of the deputy commissioner, but district magistrate to conduct an inquiry in terms of the provisions of the Telegraph Act 1885, Telegraph Act version 2. And the petitioners were also aggrieved with the rate of compensation in respect of their lines, which was fixed without issuing notice or hearing the petitioner. The petitioner in the said petition has categorically stated, in the aforementioned petition has categorically stated that the respondent number 1 passed the proceedings, specifically stated that, the respondent number 1, deputy commissioner, passed proceedings in violation of the principles of natural justice by not calling upon the petitioner to appear before him before passing such proceeding as referred here above supra in the heinous proceedings dated 18/10/2022 and 16/8/2022 inverted comma. And the petitioner was aggrieved by fixing of the land value by the deputy commissioner. Before in the writ proceedings, the perusal of the documents produced by the respondent number 2 indicate that the respondent was in receipt of the notice issued by the respondent. Petitioner. Petitioner was in receipt of the notice issued under the Act on 23/7/2023 comma, and consent of the petitioner was obtained. And on receipt of the notice for consent of the petitioner, no objection certificate was issued by petitioner number 1 for himself and petitioner number 2. At annexure R2 is the letter. Annexure R2. Is the authority letter issued by the petitioner number 1. Petitioner number 1, alva. Petitioner number 2, on behalf of the petitioner number 2. Correct. She has signed on the behalf of petitioner number 1, right?
Yes, signed. Giving the authority to petitioner number 1 to sign.
That is an authority.
Yes.
Authority letter given by petitioner number 2
Yeah.
to sign authority by petitioner number 2 in favor of petitioner number 1 to sign on her behalf. And further, the NOC dated 23/7/2023 issued by petitioner number 1. Issued by petitioner number 1 at annexure R3. R3 and R4, alva? R3 and R4. R3 and R4. Further, the agreement was entered into between the parties and compensation for the land and the crops part trees in terms of the order issued by the Deputy Commissioner. The petitioner has received compensation amounting to rupees 11,75,306 and an amount of rupees 8,24,401 towards the trees part crops, which is evident from exhibit from annexure R6 to R8. The petitioner having received the compensation as stated above in respect of the damage having stated above has also received the damage to the electrical cable, borewell, irrigation pipes, etc., which was damaged during the construction by erection of towers of the scheduled land in question. And the petitioner were paid an additional amount of rupees 1,70,221 as could be seen from annexure R2, R12. But according to the petitioner, the same was received on protest. Be that as it may, the petitioner have already received compensation from the compensation as determined by the Deputy Commissioner by its order dated 18/10/2022 and 15/12/2023. If the grievance is of the petitioner is that there is no adequate compensation paid to the petitioner, the petitioner is always at liberty to make
They themselves have mentioned.
to approach the Deputy Commissioner or the appropriate authority or the appropriate court of law seeking for enhanced compensation. Seeking for compensation. Seeking for compensation.
It's not determined.
Which is not determined. which is not determined, if the grievance of the petitioner is that the compensation is not determined,
This also may not. Structures, standing crops and plantation.
structures, standing crops and plantation. Hmm? If the grievance of the petitioner is that the compensation is not determined as per
They
his
say that let us be exercised
structures,
with the concept of authority. So they don't admit.
liberty is always available to the petitioner to approach the appropriate, to approach the deputy commissioner or the appropriate court in accordance with law. The,
You cannot be in the way of
yes, and the petitioner cannot come the way of laying line by the respondent number
They have to
in the said circumstances.
They have to exert one service.
I1 of 52 of 2024 is allowed. The interim order granted by this court on 13/8/2024 stands precedent.
One service.
No, you read petition pending, they are not.
While conducting that project, according to their own standard, they have to cause, the Supreme Court guidelines, they have to cause least damage to the property. They ಏನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರೆ, kindly look at this. One submission is not ಇದೇ ಹೇಳ್ತಾ ಇದ್ದೀನಿ, kindly look at this. ಈ ತರ ಎಲ್ಲ ಮಾಡಿದ್ರೆ ಈಗ ನನ್ನ ಮನೆಗೆ ಹೋಗುವಂತ ದಾರಿ ಅಂತ ಹೇಳ್ಕೊಂಡು ಅವ್ರಿಗೆ ನಾನಿಲ್ಲಿ ರಿಪೋರ್ಟೇಷನ್ ಬಂದಿದ್ದೇನೆ ಅಂತ ಹೇಳ್ಕೊಂಡು ಎಂಟೈರ್ ಅಫಿಷಿಯಲ್ಸ್ ದೇ ಆರ್ ರಾನ್ಸಾಕಿಂಗ್ ಅವ್ರಿಗೆ ಬೇಕಾದ್ದೇನು ಟವರ್ ಮಾಡ್ಬೇಕು. Is this a way of doing a matter?
Don't damage much. Don't damage. It appears from that. Compensation for merits ಮೇಲೆ ನೋಡೋಣ. Next. Dismissal of the appeal filed by the respondent. ಯಾರು dismissal ಯಾಕೆ? What is the suit for? Agreement. You want to still prosecute? Then you take your chance afterwards. After vacation. After vacation. Yes. In the week commencing from 21st October. Yes, Mr. Prakash. Your SP Prakash, your colleague of SP Prakash. At request of the appellant counsel, this is matter after Dasra vacation, ensuing Dasra vacation 2020. Yes, Mr. Mithun.
RA, which came to be announced, because in seeking to recall the order of
You're against the final degree proceedings.
purchaser, my rent actually should have been owned by the seller. This is large.
From whom did you purchase the property?
From the only purpose of the one going back.
Govind Raju. How many children of Govind Raju?
Govind Raju had two wives. First wife is one small, first wife is 120. Subsequently, the second wife, again named Mandala, was married in 1990. She had 4 children. He only decreased 1/7 share of Kumar and 1/7 share of Mandala. What has happened in his second FPP, even the children have drawn shares. My saving of 1986, which should have been bound by Govind Raju, this year at least should have been allocated to my rights.
It was held to be this joint family property. Yes. So to
So there
was,
is 2 shares.
correct. Was there a plea of legal necessity? No.
That is rejected. That
So
is
now-
rejected and,
Only to the extent of your share.
to the extent of both the shares should have been, and, the, RSA alerts, see the RA, what is happening, I am what has been filed for DA. It is discussed on that chapter. It's not one in place.
Then you did not challenge that order of the regular appeal before the spot.
That was challengeable.
What happened?
That was challenged, that was, filed before the RSA.
Then an observation should have been taken by you to the extent of saying that in the event in the final degree proceedings, the share that would be allotted to the father should be allotted to your share.
When you separate proceedings, then that was,
You were a party, right, in the second appeal. Now 1/7 share has been confirmed. What is it? 1/7 share.
only point is this.
When did the father die? He was not a party in the
He was
suit.
a party.
He was a party in OS.
He was not a party. Different number one and for purchase directly.
So they were not, Govindraj was not alive at
He
that
was
time.
not,
So there is a question of to his extent. The reason is after his death, they have filed a suit for partition. And they contended that the Govindraj had sold this property without there being any legal necessity. You took a plea that there is a legal necessity to sell the property. Your contention was not taken or not accepted by the courts below. So where's the question of to be allotted to the share of Govindraj? Because he is not alive. There's no notional partition here. There's no notional.
then. Then divided into three, Kumar and Govindraj. So when the property, when the super partition was filed.
He was alive.
Against him and Mantra, the secretary.
Allah, Govindraj was made. Yes, he was not there. He was not there. So having failed in your appeal,
He had been alive, the property would have been divided into two shares. One is Kumar's half a share and half a share to Govindraj. So if Govindraj's, if the property was to be in half a share in favor of Kumar and half a share in favor of Govindraj, then Govindraj's half a share would have been given to us. Or his share, whatever his share was allocated. would have
that
been
is
given to us.
available only when the other children's are there, and one of the sons sells the property. Then to that extent, it can
But
be.
here the father in this.
Now father has sold, so the
Father
content,
has-
so that is not available to you now.
Father has sued, but what the suit is been filed stating that he could not have sold the entire action, including the son's share,
Kumar's share.
Kumar's share. So if Kumar's share is excluded from the asset statement, then at least my share should be found by the extent of whatever goes that. Because
I think that proposition is not correct because he was not alive when the suit was filed, and he was that it was for legal necessity. Your
that
contention,
was the contention taken by us. The suit is filed against us and also against the.
and you have lost in all before the courts in so far as preliminary degree is concerned. If at all you had raised a contention that to the extent of father's share,
I raised the contention to the extent of father's share. So the only contention is when FDP was drawn, at least the share of both should have been allotted to my share.
that would not arise because he is not alive. So what happens? This property devolves upon this Kumar before filing of the suit itself. He dies before the
Because
suit.
property is
86,
sold in 86, suit is filed in 93.
and Govindraju was
He was alive when he
Correct,
was-
correct. Govindraju was alive.
Please. So at least his share should have been allocated in my effect. That's it.
No, correct. You're saying-
At least the FDP code looking into the equities, the section 3 should have at least said that if Govindraju's share is, he could not have sold the entire share, at least his whatever share should have been allocated to the purchase. That is purchase of 86, so it of 93. After 7 years, they find this.
Where's the other side?
It's only a continuation of delay applications. These matters have to be looked into by the RA regular. And these are
The appeal, first appeal was dismissed on the ground of delay.
delay. They are just elected. Their documentation, they have been living in food. They've been carrying out their living in food. They have not appeared to the
The appeal requires consultation. The appeal is admitted. to hear the following substantial question of law. Whether the first appellate court was justified in dismissing the appeal referred by the appellant on the ground of delay. What was the delay?
1.5 years ago.
That, and which is the next substantial question of law?
The second question of law is, I think, the share of government should have been allocated to me, but then it's converted. They also got the land to manage. 1992 it's been converted. It's going to be a substantial, right? So,
That,
92 is converted.
second appeal reached the Supreme Court as well.
The liberty has been granted without affecting the present appeal. This what has happened in RSA, the lordship said, in the other RSA number 5. The matter was remanded for fresh consideration, came to be recalled, stating that a subsequent purchaser of equity was not a party. So that was challenged before the Honorable Supreme Court. Honorable Supreme Court, by the matter, the order to dispose of the matter. The matter remained until finality, where the original suit came to be returned, stating that there is no jurisdiction. So in that suit, the Honorable Court stated that they had the property was sold with qualified reasons. Therefore, the property came to be, the suit came to be dismissed. Now that sharers and the purchaser has filed an appeal, which is pending in appellate court.
Did you raise an objection in the final decree proceedings that the share which has been allotted to the father should be allotted to you?
They did not appear before
Even before the-
they did not appear before
So
the.
once the matter, if it is to be remanded, then all the questions would arise.
Demanded and then taken.
Admit, call for TCR, paperwork dispensed. Yes. What is this?
Property to the only property. We develop the right saver data and after this we in spite of the production of the said government was the courts are going to appreciate the fact that it's that. Again, I'm not doing the for the relevant observations of those.
As the records come,
Records are not, records of the.
call for TCR. Yes, we'll ask the register, what is it? Let the TCR come, we can't allow this application. Yeah, no?
Meanwhile, my lord, there is a gift in my favor.
The gift in your favor, that is proved.
They say it does not affect because they failed to prove. I'm not on that particular. There is a objection with the first appellate court saying that should be paid to me. Because it is before I'm able to.
Let the records come, what is the urgency for you to come on? Allah, records, sorry, in the, I am considering. Whether, Allah, after allowing of your application, only then we can say then.
There is a objection to the appellate court saying.
No, 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 no.
Suppressing that cash not that because you have rent here.
No, no.
Just suppress that matter.
Next matter. Mr. Concern, let the TCR come. See, if you are entitled, you are entitled. Even if you are correct, right? They have challenged that order. Alva, they have challenged that order. We have to consider that. Without considering, Allah, let the TCR come. This requires, definitely you would not have any objections. See, We want to see whether they are justified in saying that. That's all. We want PCR to be called for forthwith. Another 1 week, nothing will happen. Week commencing from 21st. See, 21st, 2021 ದಿಂದ this impleading application is pending. ನೀವು ಅವಾಗೆ press ಮಾಡಬಾರ್ದಾ?
I was right at the time of dictating judgment, earlier argument took time.
We don't know. We don't know what transpired before the. We don't know. Some relief, interim relief is given, doesn't mean they are won the case. Alva.
First is, you know, the Janaseva works for the other.
Right.
22.
You must finish the market, it's at the very right. But we took the article. And it will be applied. Legally, the time to decree the scope of file, and then that it is a joint.
Who is appearing for the respondent? Yes. Right. The fine. The plaintiff is entitled for 1/7 share. First appellate court also has confirmed. That is not the purpose. Now, in light of the Vinita Sharma's case, now they are entitled for 1/7 share. You have not challenged that appeal. That is it not? You are not challenged the appeal of granting 1/7 share. So he is happy with Prakash versus Kaur. Now, in light of the judgment of the apex court, Tuesday. Yes, Mr. Tomorrow he will be all right. Yes. At the request of the appellant counsel, list this matter after the vacation. 2020. Yes, Mr. Prasad. No representation. This is no representation for the appellant. This matter after the vacation. Yes, Mr. Harish Babu. What is the reason for 1,386? Wrongful prosecution, huh? How could you file a writ petition against an order of KR? Against the judgment and decree now on the ground of delay. Where is the explanation? Have they filed appeared, Shravana? Where is he? He was here now. I think he thought this was the matter and then he call him. He was here now. Next matter. Just a moment, we'll pass over. Heard reserved. Reserved. Twenty-six matter, we are reserving it. 26 matter reserved. Yes, Mr. Ravi Shankar. Pass over. Right, 28 is over.
28, 20, 30, which one? Which one?
What is that we follow? No representation. All this matter after the vacation. 31 they have taken time in the first hour itself. Oh. Okay. Based on 110. In the morning hour, submission was in morning hour, time was sought by the appellant counsel. When the matter was reached, then the counsel appeared for the respondent. When the counsel for the respondent made submission that the time has been sought by the appellant counsel without informing. In light of the same, this matter on first 1st October. Yes. Yes.
Request for a passover, my lords.
Yes, the matter is to be heard.
My lords, 32, my lords, and I appear for the petitioner.
Yes,
Senior
This will
on his
take-
legs.
this would take some time, right?
Please, my lords, last time there were some documents that were given to the senior, so he wants to
Take your
come in.
chance after this vacation.
My lords, it may be passed over, my lords.
Afternoon, there is a difficulty in matter.
Okay, my lords, as you please.
After Dasra vacation 2020.
Much obliged.
With the correct next. The dictation. Dictation on Tuesday. Tuesday. Yes, Mr. Gautam.
My lords, appear for the respondent, my lords.
Giving them the review.
Yeah, please, my lords. Yes, my lords. It may be had on Monday, my lords. Joint memo of settlement. I'll file it, my lords.
On first
Yeah,
October.
please, my lords. Please, my lords. Giving the relieving letter, my lords.
Yes.
Much obliged.
Madam, on first October. Yes. Next. That matter have reserved it. It passed. No, we would always feel that respondent number 4 should take this workers for some period at least. And that is what this court felt. Though you may have been a very convincing argument, you were perfect in your arguments, but then this court has got some corner. No.
Because I understand, considering the socio-economic situation of the petition.
And look at this. Allah, look at it. You were not there when I reserved the matter, but yeah, the court feels that they were under the impression that though they are the contract workers, we are absolutely not on that. They are contract workers, they have to approach the labor court and all that. But in this case, now, they were believing that you would take them after having taken them in the light of that clause 45. They were continuing with your same status of theirs. They were not as a permanent workers or anything. What you did is immediately you transfer them to the respondent number 2. No, you did it on 29th. You did it on correct 29th. You made a transfer to respondent number 2 when the respondent number 2 was only breathing. Rather, he was not even functioning properly. Correct, right? Then respondent number 2, he gives an order immediately the next day. Next day itself, 30. So this court was always feeling, though you made an argument and I was convinced. But one thing, if you can accommodate them for few more days, rather with them, then tell them or give them a termination notice from your end because you had taken them, right? Correct. No, correct. But then you have taken them. Correct. You obliged the respondent number 2. Suddenly, if you would have relieved them at that point of time, that is R2.
Because since it was one of the terms in the tender document itself, that these were particular workers actually not to.
Correct. We are all with you. But now,
I'll make my submission.
No, having employed them for 1 year, suddenly you transfer them for no reasons. You would have employed them continuously, right? No, you are employing so many other employees. Trying to get myself into that, trying to get into that.
Time and again,
Okay. So what for this 21 workers?
hold rights in front of the factory. They don't perform any job.
Then
No, it is for not prior, not after the issuance of the communication that I would give to respondent number 2, after which the input communication was passed. Prior to this itself.
then why did you transfer them? You should have done this termination by yourself, right?
I could not do it because there was not a direct entry.
But then,
Only after because there was new event I terminated. They would have challenged the termination as having been void in the eyes of law because they were transferred, their original employer was PSCC.
but that was not, yeah, they were not in existence, right? That's why this court, correct, lesser. Now all the control is done by R4. Correct. What remains then? What remains? But see, when you take that contract workers into your employment, you are employing them, right? You are employing in the sense you are doing that contract work of they are doing the contract work with something is being done by them. Correct. So why don't you take them for some more period? That's all this court wants.
They answer it this way. I'm certainly at your lordship signed in so far as the humanitarian jurisdiction
Correct.
that your lordship is in so far as the petition.
Correct. That's all. That's all. That's all.
If I'm in a position where means your lordship that they don't have a stand in technical aspect, that the communication that I have given certainly passes the scrutiny of law and their grounds are do not merit consideration. Your lordship, in the event your lordship is inclined to consider the submission that we have raised, they certainly say that the petitioners are liberty to directly approach respondent number 4. And respondent number 4 be directed to consider their application. We shall certainly consider.
Why don't you do it now?
They have not filed any application.
No, let them not file. But in spite of that, you can always consider whether they can be appointed rather taken back to work for some more period. No, that would be not a parity or something like that. But at least suddenly if you remove them, suddenly if you say, no, you don't come to my work, come to my factory, it's little not very correct. When you are employing workers, not that you have closed your establishment, it is not.
That let them not agitate others that they are permanent workers.
No, that is not. We are not even on that permanent.
Disposal of this because I'm at your lordship's hand. Your lordship direct respondent number 4 by directing the petitioner that they may independently make an application or work at the institution of respondent number 4. And respondent number 4 be directed to consider the application devoid of what is described in the statement. And your lordship may record my submission that we should certainly consider. But the difficulty is this, my lord. The conduct of the petitioners is more than what they have projected in the petition. So they would go to every politician of the state. And each politician
overruling you. Yes. That is very unlikely.
Well, they file false representation. One would say, I want to hang myself. One will say, they have filed a petition.
Think of the society of those class of workers, right?
I'm coming to a sick industry. I've read your lordship the relevant portion. But 4 years, my lord, they were not paid. And my lord, obliging the orders that were passed by this honorable court, even to this day, my lord, your lordship may record my statement. Even my lordship may file an affidavit, I should do that. One brick is removed from point X to point Y by this petition.
Correct.
And despite that,
then when you were transferring them, you should have said, this is the thing, they're not doing so much. They're not doing the work as you are expecting them to do. This should have been the reasons, right? That is not there. You just transfer them. Yeah. See, it's like passing an interim order without giving any reasons. This would be the same thing, right?
What?
This is I'm only on
the humanitarian perspective on one ground, I'm at your lordship's side. Let them not have the benefit when they don't stand on technicality. When they don't have the advantage of in the event, my lord, this honorable court, my lord, is inclined to consider, my lord, the grounds that we have worked on legal basis, legal legs that we have. And my lords, holding that in the event the petitioners are, my lords, the stand of the petitioner may not pass the scrutiny of law. But lordship will direct the petitioners to file an application.
expressing their interest to be employed to work at respondent number 4 institute. And a direction can certainly be known as I am requesting to directly respondent number 4 to consider their application. With the direction to consider their application liberally without being irrespective of what has transpired in this report. We shall certainly consider.
Dictation Friday, Tuesday happen for dictation.
Right.
We will pass orders in the court. Reserve better.
So what happens when following ground overtake technical point that we have asked. But the difficulty is this. Can you imagine this question? Tomorrow they should not go on today. Yes, the honorable court has given a seal that we are permanent workers. And tomorrow in the event they still don't do the job, which they have not been doing since 2021, ever since this repetition is filed, till 2024. For 4 long years, all that they are engaged in the extra political activities in the factory and nothing beyond that. Tomorrow they should not go and say whether we are permanent workers, we cannot remove us at any point of time. That is only happening. Nothing beyond that.
So even if we will say that if they are the contract workers, if at all we say that employ them till such period, and then make an application and consider their application liberally.
But at this point of time, they have been employed and they have been given the.
So continue till you pass appropriate orders in the application. Anyway, let us think about it.
I'm only submitting one in the event open for them to agitate. But they are workers, and they have succeeded and they could not be removed at any point of time. Well, instead of that, my most respectful submission, greatest respect, what I am requesting the they may not stand the technicalities of law. But since they were employed for a brief period as contract workers, they may be directed to file applications for employment directly to the respondent number 2.
We were working with this respondent number 2 since 2010, right?
But not with respondent.
No, not with respondent.
They can directly approach respondent. Because we have employed lakhs of individuals. Recently, respondent number 4 has revived 6 factory members near Bihar. We are employing lakhs of individuals. They directly approach the lordship directors to consider their application should certainly take.
Tuesday. It's Tuesday. Please be present on that day. Yes. 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 Yes.
Number 3 orders.
Neglur, Arvind, yes, correct. You were not a party in that proceedings, right? Then how did you approach this court now? Challenging that order? The court is asking you did not mention that you were not a party in the proceedings. Correct. And then you're seeking for dispensation of notice to the respondents who were party there. You have to make them as a party here and then seek for dispensation. That is the procedure, that is the law. Correct. But the procedure or the law prescribes that you have to make them as a party here and then seek for dispensation. So you comply the office objection. Petitioners to comply office objection by a week. Yes. Possible. You, that is what we said, you comply the office objection. That is the office objections. Yes. Yes, Mr. Gangadharappa. First. No representation for the applicant. This is matter on first of.
25.
Yes, Mr. Harish Babu. Have you informed the? You take it after vacation. This matter after Dasra vacation 2024. 2024 in the week commencing from 28th. Yes.
27.
Yes, Mr. What happened? Is there a really a possibility of then if he's saying that he wants to withdraw the appeal, let him withdraw and then prosecute it before the yes. So appellant counsel submits that the parties are exploring the possibility of to report settlement or argue the matter as a last chance. List this matter on date after the question.
21st October.
21st. In the week commencing from 21st. No inhibitions against counsels. Okay. I'm complete. Okay, here go. On Tuesday. Yes, Mr. Counsel. Any submission? Okay. 29. Somebody, the other side took time in this. They said they will inform you. Urgent. ಹೇಳಿಲ್ವಾ ನಿಮ್ಗೆ? ಅರ್ಜೆಂಟ್ ಆಗಿದೆ. They took time. Yes.
Court officer.
The logic that I will produce third volume, page 580, lecture 30.
Page
580. The matter was heard here, and the operating portion is pending consideration. I'm reading out the second paragraph. Pending consideration of the caption petition, the execution and operation of the tariff orders for the year tariff orders and consequent impugn demand notice for stay in the next stage of the enforcement. This is not the example.
What is this peruse the interim order granted by this court? There was some interim order earlier in that petition.
Okay.
No.
There was an interim order not based on the other two petitions which were brought in the first.
This one.
That is 1058.
Ah, 10.
1058. Yes, 105895. That interim order is same as this. The exact verbatim law which is reproduced.
So in light of the interim order granted in another writ petition, this
Yes.
order came to be
Yes,
heard.
that is by the honorable same on the same, that is reiterated. There is no difference in that order and this order. But I must bring to your notice that was further modified. This was an unconditional stay, and this operates as far as not the matters that were filed in Honorable High Court at Dharwad. There is an unconditional stay, but the matters that were filed in this bench, the principal bench, there is not a modification. I am not passing. Modification. So two sets of orders are not in operation. Page 4 not first. The detailed order. The matter when the matter was finally brought. May I proceed your lordship?
Yes.
Page 6.
Ah.
In my view, having regard to the facts and circumstances, it would be appropriate in the given facts and circumstances to direct witness hearing to pay 50% of the transmission charges that have been determined by KRC within its audited. However, this on payment of transmission charges, petitioner shall. However, it is made clear that transmission is only in respect of electricity injected into the renewable energy generators after transmission. That is also clarified. What this order means is earlier from 2023 onwards, ever since these regulations came into effect that are in tune before my lord, the charges were not continuing to be levied. And those charges cannot were in vogue. 2023, 24, 23, 24, there was one set of charges. 24, 25, another set of charges, because every year not pay as. Now the Honorable High Court at Dharwad passed an order unconditionally staying all the operation of the include demands and the tariff order and consequently. But that order will not remain intact. As far as the petitioners in Dharwad, they are enjoying the benefit of it. But those which are filed here not have the 50% that as per the order that I just passed.
Yes.
Wherein,
Now, what is the demand notice?
yes, that is the order. Correction.
So according to you, the demand notice is in contravention of the tariff.
Yes.
Their
And
own tariff.
yes, that is what that is my ground. One of the grounds that these demand notices that is annexure J,
Page.
annexure J at page 184 onwards, the same one. J series 184. These are bills under the Green Energy Open Access Regulations 82. These demands are raised. So one of the contentions that we took was that this is ultra virus KERC law. Other grounds were also. In fact, those regulations themselves are challenged. Because my lords may kindly.
Now, which is the repetition reserved for orders?
The same one.
Modification order.
And the Honorable Dharwad, High Court Dharwad has just referred the matter. The matter pending.
Pursuant to the modification order, pursuant to the order passed.
Section that the order that I have read that page 30.
Was this order on? Was the modification order passed?
This order was passed.
When was this order at the Dharwad bench passed? Is earlier to the modification order, right?
Yes, 7-6.
So earlier to the modification.
I like the similar orders. I don't want to take advantage.
It is like you will be in a safer side once you deposit that amount.
I volunteer. But Lordships did not want to modify because this was not brought to the notice. This all will go by modifying also. And the absolute stage there, one set of generators are not required to pay until you those. You reserve not to pay 50% margin.
One set of persons are directed not to deposit, and one set have been directed to deposit.
And I
So now other set of persons have to be directed as a different order then.
Our 100%. So there are 3-4 regimes allowed in the unfortunately. And they are enjoying, one set are enjoying because your lordships are now the modification order law was brought to the notice of the honorable judge at Harvard also. Justice Sachin Makunor, course is modified. The honorable court was not inclined to modify the order because you argue money.
When that is reserved?
Not reserved. Our argument market. They said that.
There is an interim prayer.
Yes, it takes 79. D. Is in terms of the larva term, but 50% order is there, therefore.
Who takes notice?
That's not
DSG for
yes, DSG.
DSG.
ASG himself is not. ASG himself appeared in the matter.
Say DSG, let them
Yes.
DSGI to accept notice for respondent number 1. SCGP to accept notice for respondent number 2. Who's the concept?
Appears for all 4-2.
What about 3?
Yes, 3 not I think VN Prakash. VN Prakash not
P or B?
B for matter.
B and Prakash is directed to accept notice for respondent number 3. 4 to 6.
4 to 6. Like Shahbaz Hussain.
Shahbaz Hussain is directed to accept notice for respondent number 4 to 6. Then it cancelled for the petitioner. This draws the attention of this court to the 2 interim order granted by the ordinate bench of this court. Namely, WP 103-235 of 2024, where an absolute interim order has been granted without any deposit. And in July, on 5th July 2024, the case of Vrindavan Hydropower Private Limited versus Union of India, WP 11235 of 2024. Before the principal bench, the coordinate bench of this court has paid the demand notices, right?
Yes.
Subject to the petitioner depositing 50% of the transmission charges that has been determined by the KERC. By its order dated 6/8/2023.
24 also is 23 is not true at all. Until 23 that
So we will not set that. Transmission charges as determined by the KERC. The learned counsel for the petitioner submits that the demand notices issued by the
SLDC not changed.
respondent number
5.
5
Sure.
as
J.
per Annexure J is in contravention of their own tariff
Of the tariff order passed by third respondent.
of the tariff order passed by the third respondent. In order to maintain parity, this court deems it appropriate to stay the operation and execution of the order dated of the notice. What is that? Date.
Annexure J.
Annexure J. Any consequent orders? Annexure J. The state till the next date of hearing, subject to the petitioner depositing 50%.
Exactly not. From the date of seeking open act, the author your kindly speak of the clarification issue. However, it is made clear.
Where do you find it?
Page 6, sir. However, it is made clear the transmission charges to be paid by the citizen is only in respect of electricity injected into the console after.
Subject to the petitioner paying the transmission charges, 50% of the transmission charges in respect of the electricity injected in the renewable energy generators after the passing of this order. The passing. It would be always subject to the result of this. We will say it is always subject to the, which would be subject to the final outcome of this writ petition.
But that contention was taken and DLN Rao Senior Advocate said that unless this observation is there, there shall be entitled to a refund. The contention may be taken tomorrow. That I'm only bringing here.
No, but then what if you say it is due to it would be always subject to the outcome of the writ petition, it applies the same thing, no?
They say yes, this is explicit. I'm only bringing here. I don't understand.
You have to serve the copy upon the office objections raised by the
because
petitioner is directed to serve the petitioner to serve the petition papers on the learned counsel appearing for respondents 2 to 3 to 6. And yes. J series is that annexure J series. Yes. It is an application under 33 2B. Yes.
I pointed out that the application filed under 33 2B has been dismissed on the ground that the application ought to have been under 33 1B, seeking prior permission and not approval. In view of the fact that the tribunal comes to conclusion that the charges are connected with the dispute which is pending in ID 138. Yes.
Distinction between 33 1B is before a dismissal order, prior permission has to be taken under 33 1B. Prior permission.
No, 33 1B. If the misconduct for which the employer is imposing the punishment of termination is connected with a pending ID. Connected with the pending ID. 33 1B make it 33 1B. For any misconduct connected with the dispute, you have to get it.
It's during the tendency.
Discharge or punish whether by dismissal or otherwise, any workman concerned in this save with express permission in writing of the authority. Therefore, it is prior permission of the tribunal if the dispute, if the misconduct for which I am proposing to dismiss is connected with the dispute which is pending.
Yes.
Now, whereas 33(2)(b), if you watch it, if the misconduct is not connected, then what happens? It is post facto approval. For any misconduct not connected with the dispute, discharge is punished, provided there is no such workman that discharge is unless he has paid 1 month wage and an application has been made by the employer before the authority for seeking approval of the action.
So connected with the dispute and not connected.
Not- But both after permission or after approval would relate back to the date on which the punishment is imposed. That is the relation back. Which came into force in your judgment in the Constitutional Bench in Air Force in 1967. Now, Lord, in this case, what has happened is it is a composite punishment in respect of 2 charge sheets. Charge sheet one first is annexure A 11/11/99 and annexure B is 2000. Now,
So according to you, when there is a composite charge sheet being levied, you can either seek under 33(1)(b)
it is open to me. If one of them is connected, if the other is not connected, and if it is a common punishment, I have the choice to either go under 1 or under 2. Either 1B or 2B.
Yes.
Now, but my other submission would be that the conclusion of the tribunal, the finding of the tribunal, that the misconduct for which he was also imposed with the punishment of dismissal, which is in respect of charge sheet and then charge sheet and annexure B, would also not be, cannot also be considered to be connected with the dispute which is pending. I will point out that also. That is the. Now, when we see the order of punishment, in fact, I took your worship through the order of punishment, in just page 30. That's one sentence there, and then I will take your worship. The ID which was pending, what is the matter which was referred for adjudication? And to find out whether it is connected or not. Page 30.
Page 30 of the writ petition papers. Right?
Annexure, yes. Petition paper, page 30 is the order of dismissal.
Order of dismissal is page 31.
Now, it refers to charge sheet dated 11/11/99.
Just a minute.
Yes. In at page 31. And then Lord, it refers to the explanation and then the inquiry and then the second show cause notice. Then please come to page 33, internal page 3. It refers to the second charge sheet. 2/5/2000.
Yes. 2, 4.
2/5/2000, paragraph number 4.
That is
This second charge, you are issued with another charge sheet, that's what it is. It is this charge sheet, my lord, the tribunal holds that it is connected with the dispute. Now, my lord, what is the dispute which is pending? If you not see further down. Lord, internal page 8 and page 38. Since an industrial dispute is pending adjudication before the industrial tribunal in ID 138 in 2000, 138 of 2000, in which you are a concerned workman. The distinction is concerned workman means if it is a general dispute, all the employees who are working become concerned workman. The issue is not whether he is a concerned workman. The issue is if the dispute or if the misconduct is concerned with the dispute which is pending, then it is 1B, otherwise it is 2B. Because you are only a concerned workman, I have filed it under 33(2)B, that's what I say in this paragraph. And I pay 1 month wages, and I simultaneously on the very same day when I issue the order of punishment, I make an application with the client. Now, kindly see the allegations in the charge sheet first. Second charge sheet, 252,000.
What is the dispute about?
Yes.
Let's go to the dispute.
Yes, I tell you.
138.
Yes, 138. Order of reference your lordship would get at page 50, at page 60.
Yes.
Annexion F, page 60.
With petitions. Yes. Yes, yes. Now it tallies perhaps. That was pertaining to some IAs and the charge sheet was also available there.
Is this page 59?
59.
Yeah. See the order of reference, which is registered as ID 138 of ID 138 of 2000 by the tribunal industry. Please see the order. ವಿವಾದಾಂಶಗಳು.
Yes.
ಆಡಳಿತ ವರ್ಗದವರು ವಿಧಾನಗತಿ ಹಾಗೂ ಗುತ್ತಿಗೆ ಎರವು ಘಟನೆಗಳ ನಂತರ ದಿನಾಂಕ 8/3/2000 ಬೀಗ ಮುದ್ರೆ ಘೋಷಿಸಿರುವುದು ನ್ಯಾಯಸಮ್ಮತವೇ?
Yes.
ಫಸ್ಟ್, ಕಾರ್ಮಿಕರು ದಿನಾಂಕ 3/7/2000 ಮುಷ್ಕರ ಹೂಡಿರುವುದು ನ್ಯಾಯಸಮ್ಮತವೇ? ಹಾಗೂ ಆಡಳಿತ ವರ್ಗದವರು ಬೀಗ ಮುದ್ರೆ ತೆರವುಗೊಳಿಸದೆ ನಂತರ ನೌಕರರಿಂದ ಮುಚ್ಚಳಿಕೆ ಕೋರಿರುವುದು ಕಾರ್ಮಿಕರು ನಿರಾಕರಿಸಿರುವುದು ಮಂಡಿಸಿದೆ. ಕಾರ್ಮಿಕ ಸಂಘವು ವಿಧಾನಗತಿಯಲ್ಲಿ ಕಾರ್ಯನಿರ್ವಹಿಸಿದ ಫೆಬ್ರವರಿ-ಮಾರ್ಚ್ 2000 ಮಾಹೆಗೆ ಪೂರ್ಣ ವೇತನ ಕೇಳಿರುವುದು ಹಾಗೆಂದಿದ್ದರೆ ಕಾರ್ಮಿಕರು ಯಾವ ಪ್ರಶ್ನೆ ಆಗ್ತದೆ. The first point of dispute, you will also kindly have a look at the English translation of that the tribunal itself has made at page 62.
Yes.
Is the management justified in declaring lockout from 8/3/2000 after the incidents relating to go slow and Gera?
Yes.
Yes, go slow and Gera. Incidents relating to go slow and Gera. Go slow happens while employees are working on the factory, on the machine. They don't give the notified production, but then it is slowed down. Therefore, the production becomes slow. That is a go slow. Then Gherao is, you Gherao the supervisors, you make such certain demands. That's a Gherao. Now, because of that, when the situation went out of control, management declared a lockout. So whether that is justified. Then, are the workmen justified in going on strike? You see, what is referred is whether they are justified in going on strike on 3/17/2000. Are the management justified in demanding undertaking from the workmen after lifting lockout? Therefore, now the issue as to whether When the workmen go on strike, the kinds of misconduct they have ultimately indulged into is not a matter which has been referred for adjudication at all. That is a distinction to be made here. It's not a matter which is referred for adjudication. What is strike? I will take you worship through the definition of a strike. A concerted action.
What are the charges framed?
Yes. Now, the next one, you worship again this. There, whether is the first party union justified in demanding full wages for the month of February and March when the workmen went slow in their work? And if not, what is it? Kindly see what has happened is, ultimately, award has been passed, holding at page 157, Lord, holding that the management was not justified in declaring lockout from 832, 157.
Yes.
The management is justified in deducting proportionate wages as indicated in the tabular form mentioned above in respect of some workmen who did not give normal production. The management was not justified in withholding 50% wages to all. The management was also not justified in refusing work to workmen who did not execute undertaking containing unreasonable conditions imposed by the management. The workmen who have given normal production are entitled for full wages for the period from 13/3/7 to 12/7. The other workmen who did not give normal production are entitled for withholding of wages for reduction of after reduction of proportionate wages by the management. Therefore, now in the body of the award, the labor court has apportioned the blame on both. And on that basis, this is the award which has been given. Now, both the employees and the employer have filed writ petition and writ petition pending before this one. And there is an intermodal stay on the implementation of the award. That is the stay. Now, kindly see the this is the I have taken your lordships through the order of reference.
Yes.
What are the matter which are referred for adjudication in ID 138? Please see the charge sheet dated 2/5/2000.
Yes.
Annexion B, page 23.
Yes. Yes.
You were on duty in the first shift from 6 a.m. to 2 p.m. on 7th March 2000. So that day, you were assigned to work on 2 machine located in the main hall. While you were on duty at about 1 p.m., when the shift in charge, first shift in charge, and security officer Mr. Menon came to the main hall to disburse February month wages to employees and started calling the employees to the able to receive this shift. You suddenly stopped your work and left your workplace and went running towards the shift in charge table along with Mr. Giver and incited the workers not to take the wages by stating, Yaru payment is equal. Again, you repeatedly told the workers not to take wages. After the close of the first shift at 2 p.m. on 7th March 2000, you should have gone on to the premises. Instead of that, you led the first shift workers along with Mr. Raj and made them to squat inside the main gate, blocking the movement of all. While squatting inside the main gate, you refused to leave the factory premises when the management by its memo directed the workers to leave. And then you started inciting the agitating workmen at about 7:15 p.m. to rush towards the admin building to get out the manager present there. And you took active part in making the agitating workmen to squat in front of the cabin of the managers and to the office. Thereafter, at about 10:15 p.m., when the manager production, Prakash, who was under Iraq in the new admin building, along with other managers, was going towards the toilet room from his cabin, you along with Mr. Kanikarajo, Bhimraju, Ramesh, you were trying to run away, taking our money, and caught him by his arm and dragged him to the and threatened him that you will boot him or things. After this incident, manager production Prakash, who was made to retreat to his room for slight talk to the agitated employee and persuading them to seriously and abandon their individual job. You stood up and then started picking up. kicking on the side cabinets and told him that I want to kick you this way. Also, you were punching your hands in the air and shouted, "No, you are not the continues back inside the administrative building, hurling abuses against the manager, shouting slogans, intimidating and embarrassing. Thereafter, you started inciting, agitating workers to go to video about 12:30 on 8/3/2000 and around the vice president for 4:30 in video in the first one. After seeing that the safety leads to video was blocked by the manager Mr. Gangadhar and other managers, you started telling the employees to push the managers in order to encourage them to move on. You along with the to demand employees towards the manager so that they are pushed back and you wait. In this process, when your attempt to enter PDA was to be resisted on the list, you rush towards the manager production in a telling manner. Once the entity employees raised their rate, and started amounts to misconduct under the column. Please see misconduct for which are in charge. Use of indecent behavior and
This is second charge.
in the second and superior and using abusive language. Then participating in a staying, right? Number 3, commission of any act supposed to discipline. Then disorderly behavior. Then threatening or assaulting or misbehaving with any officer. Then any act of coercion against the management or against any. Then conduct within the factory in a manner which is likely to endanger.
Yes.
And now, first charge sheet, if you also see, this is the annexure A, page 21. That is with regard to leaving the workplace on 9/11/1999 and found sleeping and then not obeying the orders to work with the machine. Now, the second charge, which is what we are concerned with now, because the tribunal holds that this is connected with the dispute. Now, the lordship says, you see, this has nothing to do with the order of reference, which relates to declaration of law and continuation of law.
Yes.
Now, whether it was a concerted action on the part of employees, which amounts to a strike and harassment, which ultimately resulted in declaration of law, is a common issue which has been gone into by the tribunal. It is, and individual participation of employees indulging in either threatening or inciting or indulging in acts of using abusive language or pushing and assaulting officers, which is the actual charge in the charge sheet. It is not a matter which has been referred for adjudication in ID 1. Yes. Though these actions may have ultimately resulted in a lockout, which has been gone into, but there is no connection in the sense that is contemplated under section 33(1)(b) is the now. Though I may at this stage itself point out, Bhimaraju and then the Kanikaraju, against whom identical charges were issued. Now, there again similar applications were filed and they were rejected.
Yes.
They were also rejected on the ground that they are against it is against those two. I'll come to that. Now, there what happened, the management filed a request. Then Supreme Court directed the parties to see whether was rejected. It was not a considered order, but it was rejected at the stage of revision. Therefore, no matter orders in respect of passed by the tribunal in respect of similar charges against Telecast or Vivalaju cannot be a precedent in this case. If I am in a position to point that these issues are not considered in that case, because eventually it can operate as res judicata only between the same parties, not in respect of the same incident. If it is between the same parties, now as far as Telecast and Vivalaju is concerned, right or wrong, I am bound by that is over. Now, in this case, I have taken up these grounds. This is not considered either by the tribunal or by this honorable court or by the honorable Supreme Court, and therefore that cannot stand as a precedent to hold against me, and that would not operate as a res judicata also.
The charges leveled against Kanikaraj and B.R. Bhimraju were same.
In respect of some of these matters are similar.
Yes.
In respect of this, but anyway, the other issue regarding two charge sheets and then I had an option, that is not considered there. No, that is also not considered here. One thing. And then subsequently, we got a recent judgment of the Supreme Court.
Yes.
In respect of an identical issue. The Honorable Supreme Court that pertained to Tamil Nadu our court order. The Supreme Court has made a certain distinction there. There, the dispute, there was a conciliation pending. Because certain demands were raised by the employees, union. And then pursuant to those demands, because management was not yielding some strike thereof took place. And matter was pending in conciliation. And then during that pendency, one more issue came in, and then once again one more conciliation happened. And on that basis, disciplinary action was taken. That Supreme Court has gone into it, where that has nothing to do with this individual misconduct. That is not the one which the labor commissioner would undertake in a proceeding in conciliation matter, and therefore that cannot be connected, and therefore they say that 33(2)B is the proper application, right? Which is directly applicable to B. I will take the lordship. Now the lordships are aware.
How many workmen were involved in this Girao and this?
There were.
So they were the workmen. Yes.
Yes.
All the employees of the water.
So they were represented by the union in that.
Yes. We are not on the issue of action being taken against X, Y, or Z. The scope under 33 is very limited. The lordships are not required to go into the merits of the matter as to whether there is discrimination in not taking action against others, and as to whether the punishment is proportionate to the gravity. Those are issues which are not germane to matters to be decided with 63, and therefore, your lordship, by deciding this matter under 226 relating to 33, the scope of interference is limited. If there is no technical error, the bar must be lifted and permission must be granted at all. Permission or approval must be granted at all. This is not the end of the matter. This is just lifting of the bar. The main issue on merits would arise because the employee has a right to raise a dispute at a section. And now we are, even after grant of approval, 10(4)A is that one can straight away go to 10(4)A. In those proceedings, that is not important. Can be tribunal, can go into all those. Now, if you paragraphs in the order passed by the tribunal, I would like to take it. Now, your lordships are aware then whether it is under 33(2)(b) or 1(b). Whenever an application under 33 is filed, if the order of termination is preceded by the preliminary issue regarding validity of inquiry must be framed, and the tribunal should give a finding on the preliminary issue in the first instance.
Yes.
And thereafter, consider whether the inquiry report given is based on some material or record. It's not legal evidence of record. Because it is some material, especially under 33. Interference, it is only when there is a plea of victimization and court records a finding that this is actually not punishment for misconduct, but this is a punishment for creating an activity. It is only then it becomes victimization. In this case, there is absolutely no pleading regarding victimization. Now, kindly see the order of the tribunal, which commences at page 128. Para 1 to 18, the tribunal refers to the various contentions of the parties in the claim and there. Please, will not come to para 20 at page 160.
Yes.
By an order dated 26/9/2012, this tribunal held that the inquiry held against under charge sheet dated 11/11/1999 is fair. The domestic inquiry held in respect of charge sheet dated 2/5/2000 is not fair and proper.
Yes.
Then kindly come to, therefore, the
Yes.
first charge sheet, the tribunal records a finding that the inquiry is fair.
Yes.
The second charge sheet, the tribunal holds that the inquiry is not fair. Therefore, from para 11/11, the findings on punishment order in respect of charge sheet dated 11/11, as can be seen from the law laid down by the Honorable Supreme Court in ruling dated so, by considering the unlike in the case of as to see whether there is prima facie evidence, Exhibit A11 is charged. It is a charge against first party that on 9/11/1999, he was working in night shift on 2/20 shift with other co-workers. He was absent from the workplace between 58 days. When MW1 inquired the question about the first party claimed that he was near the machine, and if MW1 wants, you have to he misbehaved with him. He unauthorized absence from place of work using of impertinent which indecently where gesture against his superior disobedience of instructions which behave with any officer and commission of any act. Exhibit M12 is the reply given to Exhibit 10. In the reply, the first party has admitted that he was on night duty on machine T25 during the intervening night on November and 10/11. He states that he was not absent from the place of work between 2:30 and 3:30 AM. He also denied that he shouted at MW1 on that day. He gave usual and normal production. He may be exonerated from the charges. Before the inquiry officer, MW1 Amarnath was examined. The evidence of MW1 that he was working in the organization, not in the, he knows the opposite party. The opposite party was working. He knows the opposite party for the last 10 years. His relationship with the opposite party are cordial. He was working in night shift between 10 p.m. on 9/11 and 6 a.m. on 10/11. The opposite party was working on machine 225 there. And
There was a lunch break.
there was a lunch break between 2:30 to 3:50 p.m. The opposite party was expected to be at the place of the party at 1:50 a.m. after lunch break. The opposite party was not there in the department from 2:30 a.m. onwards 3:50 a.m. He tried to locate the opposite party but was not able to trace him. He also told the security officer who was on duty to take the first party and he was not able to. About 3:30 a.m. the first party himself came and resumed work. The NW1 asked the opposite party as to where he had been between 2:30 and 3:30 a.m. At that time, the opposite party replied in loud voice that he was near the machine only and NW1 may make complaints. About 6:30 a.m., NW1 talked to his boss. After the instruction, CJ complained. The NW1 was cross-examined by the it is elicited in cross-examination that on 9/11/1999, the NW1 was on third shift between 10 p.m. to 6 p.m. It is submitted by the High Council that the evidence of NW1 is contradictory only on the basis of the evidence the opposite party. As against this, counsel for the applicant that the evidence of NW1 is sufficient to hold that the opposite party. Sir, it is submitted by the High Council for that the evidence of NW1 is sufficient to hold that the opposite party has committed the conduct of the opposite party is unbecoming. There is no reason as to why NW1 Aparna should be followed. The thing is elicited in cross-examination to discard this evidence regarding unauthorized action. But during cross-examination, some suggestions were made and the sentence denied. The witness has denied suggestion that he did not speak to opposite party and opposite party did not reply. After the incident, on the following morning, NW1 consulted the superior tried a complaint. The suggestion was made to the witness that he has not written a complaint. Further, the question was put to interview that what is the proof that he has filed a complaint in the sector. NW1 replied that the secretary officer was informed that the first party was not presented for 250 years and he instructed to search the opposite party. Further, in cross-examination, NW1 stated that he does not remember whether production was affected in the. He further states that he does not remember at present what was the production on the day. In cross-examination, NW1 Amarnath stated that there is no order in writing as stated in that the workers in the department sorry, he has stated in his cross-examination that somebody will always be there. In the cross-examination, the opposite party was not able to make anything to dispute the evidence. But there is prima facie evidence on record to show that first party has. Therefore, of the charge sheet, where inquiry was held fair and proper, the tribunal proceeds to hold that the finding recorded by the inquiry officer is just and proper and be fully verified. In regard to second, please. Paragraph 6. It is the case of the applicant that the opposite party was on duty in the first shift between 6 a.m. to 2 p.m. on 7th March. He was assigned to work on 223 machine during morning. At about 1 p.m., Sri P.G. Dinesh, in the charge sheet, in charge of the first shift, came to Mainhorn to discuss wages to the employees. They started calling the names of employees to the table to wages. The opposite party suddenly stopped and came running towards the table of the shift in charge. The opposite party was accompanied by Karnataka and decided that the should not take place. The opposite party repeatedly told them. After closure of the first shift at 2 p.m. on 7/3, the opposite party should have gone out of the system. Instead, the first party let the workers working in the first shift along with the Karnataka inside the main building, blocking the movement of officers. While starting inside the main gate, opposite party refused to leave the factory. When the management, by its memo, directed the workers to leave the factory premises, they did not. Opposite party started inciting the agitating workmen at about 7:50 p.m. To rush towards the administration building to withdraw the manager present there. First party took active part in making agitation, agitating workmen to strike in front of the manager and to get out. At about 10:15 p.m., when Mr. Jayaprakash, manager production, was going towards the project from his cabinet, Mr. Satyanarayana, Karikaraju, Bhimraju, Ramesh, and opposite party suddenly rushed towards him, saying that you are trying to run away, taking our money. The opposite party caught hold of Jayaprakash by his arm and dragged him till the staircase and threatened him that he will be booted. He will boot Jayaprakash first. After this incident, Jayaprakash was made to retreat to his room, and Jayaprakash was trying to talk to the deputy employee and abandoned their taking. The opposite party stood up and started picking on the side cabinet and told Jayaprakash that he wants to pick him in the same way. The opposite party was also punching his hands in the air and shouted that he wants to give punches like that and break the jaw. The opposite party and other workers continued to start inside the administration building, and shouting slogans, intimidating and threatening. Since the domestic inquiry held against the opposite party was found not fair and proper in respect of this charge, the applicant examined AW4 Malana, AW5 Jayaprakash to prove the charges against the opposite. The opposite party in support of this defense examined himself on victimization on also and will also accept and has also examined one of the. It is the evidence of AW4 Malana, after working that is working on the house security agency. The applicant entrusted the security work with house security agency. He was posted to work with the applicant. On 17th April, about 1 p.m., the security officer came to the hall for distributing the services. When they were distributing the service, the first shift employees came near the table. At that time, the opposite party and others came near the table and asked the workmen not to take service, and after the shift hours not to go home, but to assemble at the main gate. Opposite party and other workers were informed by putting up a notice by the management that they should not stay within the premises of the factory after their shift hours, but they refused to follow the advice of the opposite party, along with first shift employees, blocked the main gate and prevented movement of. At about 5 p.m., first shift employees and the general shift employees together at about 7:15 p.m. came to the administrative building to allow all the managers to enter. They are also blocked the cabins of managers and were abusing their inferior. About 10:15, Jayaprakash, production manager, was going towards the project. The opposite party and others got hold of it and they did not allow him to go. They were abusing him in. About 12:30 a.m., this was Vice President was sitting in video. Mr. Jayaprakash and Nandrajaya were standing near him, reading the video. The opposite party and other employees pushed AW4 and others aside and forcibly entered into the video. They bolted the room. The Vice President was put out by the opposite party and other workers. They were abusing Vice President. At about 3 a.m., on the instructions of the Assistant Commissioner of Police, a meeting was going on in personal manager's time. The Assistant Commissioner of Police was bringing word president. The opposite party and other workers prevented. The opposite party was instructing the other person not to allow the work to stop. The Assistant Commissioner of Police was brought to Vice President from the personal manager's party and other using it. On 8/3/2001, the opposite party and other employees blocked the managers by sitting on the staircase. They did not allow them to go home like a dog. The lives of the officers were in the sheer side of evidence of AW5 is also. It is submitted to the 11th of the that the evidence of AW4 and AW5 are sufficient to hold the sheet. This case being a serial application, this session has to see whether there is draft is available. It is further submitted that looking to the nature of misconduct committed by the applicant, order of dismissal passed by the applicant and does not call for it. As
Continue on Tuesday.
I have to take the lordship through the reasoning given by the judge.
Tuesday, you both of you will complete the arguments. So you complete and then you argue. Tuesday.
Once I take your lordship through this, may not be listened from because I am taking your lordship through the entire.
Correct. This court is not sitting tomorrow. October 1st for further hearing. In the morning hour itself. So we'll have the whole day for hearing the arguments after the other matters have been taken. Further hearing. Further hearing. Court is not sitting tomorrow. So we'll be sitting only on 1st. Tuesday. Tuesday is October 1st. Friday and Monday. Both days. Tuesday.